able.
Yes, Mr. Beltrami.
Lord, thank you. Adrian Beltrami for the Appellants, Mr. St. Quintin for the Respondents. It's appeal from the order of Marcus Smith, J, the 16th of June 2025. The judge dismissed the Appellant's application for summary judgment in relation to part of the claim, but granted permission to appeal. The appeal, my Lords, raises two issues of statutory interpretation concerning sections 25 and 30 of the Trademarks Act 1994, on which there's no prior authority that anyone has found, and there seems to be nothing of any interest in the textbook. The factual background, very briefly, just so your Lordships can see how we've got to where we have got to. One can pick up from the chronology, core bundle, tab 7, page 83. The respondents are the registered proprietor of relevant trademarks bearing the sign Beverly Hills Polo Club. That's the first respondent, the registered proprietor. The second respondent is the exclusive licensee of those marks. On the 11th of September 2015, the respondents commenced infringement proceedings, alleging what they said were 2013 acts and 2014/15 acts. There was a liability trial before His Honour Judge Pelling and judgment on the 20th of April 2018. The judge found infringements by most of the defendants by reason of the 2014-15 acts, not the earlier ones, and also liability and tort for inducement of breach of contract. On the 4th of April 2019, the respondents elected an inquiry for damages. On the 30th of June 2023, the original particular claim in the damages inquiry was served, and was then an amended version. And on the 17th of February 2025, application for summary judgment. But putting a little bit more flesh onto that, if you can go back to the core bundle, tab 12, page 120, is the claim form from September 2015. The details of claim are at page 122, and one can see from the top the claimants sought declarations, injunctions, order for payment of all sums due by way of an inquiry as to the damages or the claimant's option and account of profits. And if we turn to page 148, having set out the acts of alleged infringement, the claim at paragraph 39, in terms of remedies, by reason of the matters aforesaid, the claimants in each of them have suffered loss and damage in respect to which the claimants in each of them are entitled to, and will seek an inquiry as to damages or an account of profits. And then one can see that followed through in the prayer on page 149, number 3, an inquiry as to damages suffered by the claimants and each of them. And certainly at the outset, just putting this in context, this was a claim brought, and brought only by the respondent claimants on their own behalf, alleging loss suffered by the respondent claimants only. And insofar as it sought an inquiry for damages, this was in respect of damages suffered by the respondent claimants. It was not a claim as brought on behalf of licensees or for the recovery of licensee losses as distinct from claimant losses. One can see the change in the amended points of claim in respect to the damages inquiry, tab 15, page 192. So this is the amended version. The original version, as I said earlier, was served in 2023. This is the 2024 version. But if we go to 195, the claim now, at paragraph 17, the claimants claim for all the loss they and or their licensees have suffered as a consequence of the defendant's act of infringement passing on. There was no finding of passing on and or inducement to breach of contract. And the losses they then articulate in the pleadings are summarized in paragraph 17. So there are losses direct losses to licensees at 17.1 outside the UK. There's loss of revenue at 17.2, costs incurred by the claimants, and reasonable royalty of the claimants. And there's then detail of that set out from 18 onwards. And in broad terms, a number of licensees are mentioned, albeit it's not said all licensees are referred to. There's a variety of claims for alleged direct loss from the licensees and also loss of royalties by the claimants. We have indicated in our evidence, I don't think it's subject to any challenge, certainly not for present purposes, that the damages claim, there are various models set out in the damages claim, but doing the best we can to work out what the claims are, we understand that the total damages claim now is in the region of £7.7 million, of which licensee damages claims are £6.3 million, and the balance being claimant claims. So the licensee claims are about 80%, as we estimated, of the total damages now claimed.
Sorry, can you give me the licensee figure again?
The licensee figure, 6.3 million,
Oh, yes,
of a total of 7.7 million.
Sorry, my fault, I transposed the figures, thank you.
Points of defence, paragraph, page 216, and just to see the context, and at 218, the infringement submitted to the 30th of June 2016, and it's pleaded at paragraph 20 by the appellants that the licensee claim couldn't be maintained in the absence of registration. That was then responded to on page 259, paragraph tab 19, paragraph 4 and 260. Essentially, a single point taken was that they didn't need to plead, they didn't need to register licensees' losses because all licensees' losses must be taken into account in any event under section 30, subsection 6. That was the basis of the pleadings. There's then the application for summary judgment, and the respondents' evidence and response raised a second point, as we'll see in the judgment. If one can turn to the supplemental bundle, tab 3, page 42, the respondents' evidence in response to the summary judgment application, and moving on to page 46. Paragraph 17 was the pleaded point, i.e. it's not necessary to have registered the licenses because it's section 36 is mandatory. I'm going to refer to section 36 many times. I don't mean 36, I mean 30 bracket 6. The second point advanced on page 48 is that even if registration was required under this statute, it could still be done at any time in the future. And one can see at paragraph 25, halfway down the paragraph, even if it were the case applications were necessary to register, there was nothing outside the claimant's control to prevent them from making such applications before the second trial or before the relief that takes into account the losses of licensees is ordered. So that the point being addressed, as we understood it, is even if registration were required, an application to register could be made the minute before an order for judgment was given, and it would still satisfy this section. And that's the basis of which it was put. It was not said that they would register. It was not explained why they hadn't registered. It was said it was capable of being registered at any point until judgment.
The statement is made the claimant's preference is the identity of the licensee is not publicised. Was that elaborated on at any point?
I don't understand that to have been elaborated on any point beyond that.
Thank you.
Now that then led to the hearing of summary judgment, and Marcus Smith J identified how things had moved on a little bit by that stage, going back to the core bundle. Tab 9, page 98. At paragraph 24, a reference to the evidence we just looked at and looked at the skeleton argument, the judge referred to the question of cure by, I'm going to call it late registration, but I think we should know what I mean by that. And the judge was informed, as he says at paragraph 24, that an application had been made shortly before the hearing to register one licensee, or in fact a sub-licensee, and that's known as, he refers to as harvest. And post the hearing, there was a letter of the 18th of April from the IP office that the application had been accepted. The judge then identifies the terms of that license, as you see running on page 99, from 2017 to 2020. And as the judge notes, thereafter, it had expired 2020, and it only started after the infringement period. The judge thought, didn't quite understand the relevance of it, but there it is. That was the evidence before the court, but certainly by the time we get a judgment, as the state of registration. The claimant, respondents, had chosen to register one license, and one license only. And just so far as we're aware, there's been no application to register any other licenses, albeit my friend Skeleton, paragraph 2, indicates it can still be done. So they're maintaining the position we saw in the evidence that it's still possible to do something that they haven't yet done, or indeed even promised to do. So that's the background. The statutory provisions at the centre of the appeal, just so your lordships can see them before we delve into the detail. Authorities Bundle, tab 15, page 382. And I'm sorry that it's perhaps not as... We have to do a little bit of work to work out what's relevant and what isn't. The relevant parts are 25.3. So if we go to 382, section 25, there are two versions in the bundle of section 25. The version at 382 is the now current and at all times applicable version.
Can I just put in a plea for future cases that the numbering follows the same course, electronic and paper?
Oh, it doesn't.
No, four apart. So I'll get used to it. But
do I have to add or to subtract? I can do my best.
I'll tell you when I've worked it out.
I do apologise.
What page are we in your version? Are we in 25 as enacted?
25 as current.
Right, so we're in the second tab for section 25, and we're on paper 382.
Paper 382, Lord.
Right, for information, I can add 4 to all your references, and you don't have to do it.
I do apologise for
Not
how irritating that. So 25 is the then applicable and still applicable version of this section, and we'll come back to 25.3 and it's what we say its meaning in due course. But as your lordship I think picked up, there was an earlier version when it was enacted, which is paper 380, and there's no change to 25.1, 2 or 3 that remained the same, but 25.4 as enacted was changed into the current version. And we may come back as to the significance of the change, but just so your lordship has the chronology, it was as your lordship knows, amended by the IP Regulations 2006 to give effect to the IP Enforcement Directive of that time. So 25.1, 2 and 3 are unchanged. 25.4 was modified in 2006. That's why I say the modified version was the always relevant version for our purposes. So that's 25. If we then go to paper 390, section 30, and this also comes in 2 versions. Section 30, so page 390 is the original as enacted version of section 30, which was operative at the time of infringement, at the time of the claim form, and the liability trial and judgment. And as you'll see the heading, and we'll come back to this in detail, general provisions to rights of licensees in case of infringement. This was subsequently amended onto page 386. An amended version of section 30 by the Trademark Regulations 2018, which came into force on the 14th of January 2019. Now, there's a slight change, and I'll show you the detail of this, as to the structure of remedies between the 2 sections, albeit there's no actual change to section 36, which is our central one. The regulations say it came into force on the 14th of January 2019. There isn't any real clarity as to what you might say are transitional provisions in relation to that. Maybe by this stage, liability had already been ordered by the judge. So there's a question as to whether the amended version has any real relevance to our consideration, but we can look at some of that in due course as well. The only other piece of statute, just to mention, and we'll have to come back to this, on 387, which is unamended all the way through, is section 31. Because section 30 refers to remedies for licensees, and section 31 refers to remedies for exclusive licensees, and those two sections are mutually exclusive. And there's some relevance when we come to compare the two. So that's the statutory material. If we can go back now to the judgment, Core Bundle 9, page 100. The judge identified three issues. Paragraph 25, Roman 3. Issue 1, essentially, does registration need to be made? Issue 2, must the sub-licensee be joined? And issue 3, if registration need to be made, can it be cured after the event? Now, issue 2 was essentially a bit of a non-issue with respect to the judge, because joinder wasn't sought by the respondent claimants, and the basis of the objection wasn't the absence of joinder. But the judge did consider it relevant to the overall review of the statute, and he concluded that the licensees couldn't be claimants, and so couldn't be joined. The first issue and the third issue are matters which are the subject of the appeal. But it's appropriate, I suggest, to start, at least briefly, with issue 2, because it does demonstrate how the judge at the outset failed to give effect, we say, to the statutory scheme. One can see the error then creeping through when we get into the other issues. Issue 2 was the issue which the judge started with, and we can pick it up at page 102. Paragraph 39, joinder of a sub-licensee. And the judge's conclusion in this analysis, 39 to 42, is that, as he says, for the reasons given in 26 to 28, a licensee normally has no right to bring an action against a third-party infringer, varied so far as exclusive is concerned, but doesn't extend to any other licensee. Then he refers to 30, subparagraph 1, and then 41 he says, there's no proper way in which licensees of the exclusive licensee, that's the second respondent, could be claimants in these proceedings. The answer 2 is therefore, subject to the right to intervene in section 36A, which is the amended version, a sub-licensee cannot be joined to these proceedings. Now, just to explain, when he says at 39, for the reasons given in 26 to 28, that's the part of his judgment where he discusses the fact that the licensee doesn't have a property right. No, the property right is only by the registered proprietor. Problems with this, we say, are significant problems. We know the judge was just looking at the amended version because it refers to section 36A, but he was, we submit, wrong as regards the original version, and we say the applicable one, and indeed wrong as the amended, because in each case he failed to give effect to the scheme set out in the section. Yes, it's correct, as the judge noted in 26 to 28, of course, that the licensee has no property right, but that is why he's given statutory rights in section 30 and indeed section 31. And it's important to see what those rights are, we submit, within the structure of the Act. Going back, therefore, please, to the authorities bundle, some trepidation. Tab 15, paper 373. And very briefly, as far as the sort of bird's eye view takes us. So section 9, the proprietor has the property right. The proprietor registered mark has exclusive rights in the trademark, which are infringed by the use of the trademark. That's the proprietor's right. moving on to paper 376, section 14, the proprietor's action for infringement. Infringement of a registered mark is actionable by the proprietor. In an action for infringement, all such relief by way of damages, injunctions, accounts, or otherwise is available to him, as is available in respect of the infringement of any other property right. And just pausing there, one of the issues we have to grapple with a bit later on is, we say, the fact that section 14 gives the proprietor everything he needs and everything he's entitled to. So under section 14, he is entitled to damages equivalent to the same as any other property right damages. Everything he needs in respect of his loss is there in section 14. That is his remedy, and all he needs, and in fact all he's entitled to, as a matter of ordinary principle. We then move on to paper 385, the licensing section, which is part 1, registered trademark licensing. This is section 28 to 31, the section on licensing. Section 30 we've looked at, 386. That's the amended version, but we can go to the 390, the original version, the rights of licensees. And section 31, as we know, the rights of exclusive licensees, albeit only a particular type of exclusive licensee. 387 paper, it must be an exclusive licensee who has the rights provided by the license. But not every exclusive licensee fits into section 31, just an exclusive licensee who has a license which provides that the licensee shall have the same rights and remedies in respect of the grant of the license as if the license had been an assignment. So what this statute provides for, we submit, are 3 sets of statutory rights. Section 14, the rights of the proprietor in full. Section 31, the rights of what I would call a qualifying exclusive licensee. So to get into 31, you must be an exclusive licensee with the right license that says you can do so. And section 30, the rights of all other licensees, which will be non-exclusive licensees and non-qualifying exclusive licensees. And they're all mutually exclusive. Now, looking solely at section 30, on paper 390, the original section 90, the rights of the, I'm going to call him a licensee for the sake of, or non-exclusive licensee for the sake of clarity. The rights of the non-exclusive licensee in section 30 are set out. So at subparagraph 2, the licensee may call on, unless his license or any other license is derived, provides otherwise, he may call on the proprietor to take infringement proceedings in respect of any matter which affects his interests. So again, we're departing from section 14. We're concerned with matters which affect the licensee's interests. And the initial right of the licensee is to require the proprietor to bring proceedings on the licensee's behalf. Subparagraph 3, if the proprietor refuses to do so or fails to do so within a period, the licensee may bring the proceedings in his own name as if he were the proprietor. Section 4, proceedings are brought, the proprietor has to be joined. And then subsection 6, in proceedings by the proprietor, any loss by the licensee shall be taken into account. That's the structure, and we say the points that one can draw from this are as follows. First, certainly under the original scheme, and contrary to the interpretation of the judge, the licensee does have a right to bring proceedings in certain circumstances, namely the section 30, subsection 3 circumstance. So if he calls on the proprietor doesn't do it, the licensee may do it. So the judge didn't follow through the scheme to that point. But second, more significantly for present purposes, we submit, when broken down into its component parts, section 30 provides a coherent structure to enable the licensee's rights to be vindicated. The licensee has no recovery rights outside the statute, that is clear, but here he's given the statutory right to call on the proprietor to bring a claim on his behalf, and if that right's exercised, that may lead to one of 2 outcomes. The proprietor may bring such a claim, or if the proprietor refuses to do so, the licensee may bring such a claim. So it's a diversion. You may call on it, the two versions. The proprietor may claim on your behalf, or you may do it yourself. That's what this section we submit allows for. But that still leaves a gap. A logical and a legal gap. It's one thing to bring a claim, but the claim has to be capable of recovery. And this is where section 36 fits in, where the proprietor brings a claim on behalf of a licensee, pursuant to his request. There has to be a mechanism to enable the proprietor, who's the claimant, to obtain the licensee's damages, because the proprietor as a claimant couldn't otherwise do so, of course, under normal principles. And that's where we submit section 36 fits into the scheme. So request, proprietor claim, licensee claim. If it's a proprietor claim, there's a gap. Section 36 fills that gap and enables the proprietor to bring a claim in respect of licensee losses and then to recover licensee losses in the action.
So 6.6 kicks in on the back of 2.
Yes, it's a waterfall, if you like. So you make the request, you want your interest called for, something may happen. The proprietor may say, fine, you can join my action, or I'll bring my own action on your behalf, no problem. The licensee can sit back and allow that to happen. The proprietor can say, no, you're on your own, the licensee can do it himself. If the proprietor is the one who runs the action as the nominal claimant, you need to have a provision to enable the proprietor to recover the licensee's damages. That's how we say it. Now, just so you have it, the detail of the structure changes a little bit on the amendments, but not, we would say, materially. Paper 386, 1A is an addition, except so far as the license provides otherwise. A licensee may only bring proceedings for infringement with the consent of the proprietor. So the structure of request has been modified a little bit, and the licensee now must do so with consent, or if the license allows it. So there's a different mechanism under which the licensee can bring his proceedings.
I'm sorry. Could you just give the subsection you were referring
Subsection 1A. So this is the amendment, the 2019 amendment to section 30. So it's like after our period, but one can see the structure changing, but not materially so. So before there was the request, action, non-action route. Now under 1A, it allows for, if the license allows it, he can bring a claim, or otherwise he needs the consent of the registered proprietor. Now, the request and then proceeding route is still here, but it's now limited on these amendments to the exclusive licensee. And that's what I would call a non-exclusive licensee, the qualifying or non-qualifying licensee. The qualifying exclusive licensee is still under section 31. He's catered for under 31, and we'll look at that in a minute. So the exclusive licensee referred to in 2 and 3 is a non-qualifying exclusive licensee who doesn't get into 31, he's stuck with section 30. And he's now the one who's got the request proceeding route. So exclusive licensee may call on the proprietor to request, and then there's still a refusal provision and the claimant provision, and the continuation of section 36, which of course you still need, because under this route, the proprietor can still bring a claim following a request on behalf of the non-qualifying exclusive licensee.
Right, so you say that the change that's brought about takes place at an anterior point in the sequence of possibilities,
Yes.
and that the link between 2 and 6 still remains.
It's still exactly the same. Section 36 is still needed because all that's happened in the amendments is they've modified a little bit the routes, but there's still a route under which one of these parties, a non-qualifying exclusive licensee, can make the request, and there's still a route by which the proprietor can still bring proceedings on his behalf pursuant to that request. So you still need section 36. So there's no change to this substance. There's just a little modification as to how the different routes work.
And how does 6A make any difference if it does?
6A is an additional route for the licensee. It doesn't make any difference to the analysis. As we saw at 1A, the licensee can only bring a claim now. This is the non-exclusive licensee under 1A. Can only bring a claim with a consent, but he's given us an additional power under 6A to join proceedings.
Right, so what's happening, you say, is not changing the strategy, it's simply adding models by which this can be approached.
We were unable to identify the particular rationale for these modifications, but none of the modifications changed the core structure, we say. There are some bells and whistles. They've taken away a bit of a right and added a bit of a right, and they've introduced the right to join.
Is there this slight change, which is that your connection between 2 and 6, which in the original version applied to all licensees, now only applies to exclusive licensees?
Yes.
But section 6, subsection 6 still applies to all licensees?
Yes. And
So,
subsection 6A still applies to all licensees.
No, subsection 6 I'm talking about.
Subsection 6 still applies to all licensees. Yes. So that's why we say that the structure is, the relevant structure for our purposes, we say it's the original, but the amended version doesn't change the core analysis. It just modifies the routes by which licensees or exclusive licensees can exercise their rights. Now that takes us to the judge's first round of appeal. If we can go back, please, to the core bundle. Tab 9, page 100, and I think my page numbers are the same for this one. So the issue number 1, as identified, in essence, is whether registration is a precondition to access to section 36. And that requires a consideration of the interaction between 25 and 30. No, I'm afraid I need to go back. Back to the authorities. So you see section 25, tab 15, page hard copy 382. And this is the current and applicable 382. And the relevant sections 25(3)(b). So 25, we looked at 30, 25, until an application has been made for registration of the prescribed particulars of a registrable transaction, ineffective as against the person acquiring a conflicting interest, and then B, and a person claiming to be a licensee by virtue of the transaction does not have the protection of section 30 or 31, brackets, rights and remedies of licensee in relation to infringement. So 25(3)(b) is what we say is the gateway for the protections in 30 and 31. Now, how the judge dealt with that on page 104 of the full bundle, at paragraph 50, it said, it's clear from the word of the Act that until an application has been made for sub-license to be registered, a licensee has no right to intervene in proceedings pursuant to 36A. Come back to that point, we say it's significant, but he's talking about a slightly different section at this point. 36A is an express protection for the licensee. Put another way, protections conferred on a licensee by section 30 are expressly contingent on an application for registration having been made, but it's clear that the loss of protection applies only to the licensee and not to the proprietor. 52, the loss of protection is thus personal to the licensee, conferred on the licensee. The opening words of section 36, which he sets out, says this is not a protection conferred on the licensee. It requires the court to take into account licensee losses so as to avoid a black hole when assessing a proprietor's claim. The absence of an application to register the license has no effect on a proprietor's rights under section 30. So the analysis of the judge is, because it's a proprietor's claim that's being referred to in section 36, it's a proprietor remedy, not a licensee remedy. And he then gives a little bit more analysis at 55. He says the following final points arise in relation to issue 1. The latter half of section 36, the court may give directions as it thinks fit to the extent to which the plaintiff is to hold the proceeds of any pecuniary remedy on behalf of licensees, is a protection conferred by section 30, and so only available to a licensee where there is an application to register the license. So the way the judge approached section 36 was to divide it in two and say the first half talks about a proprietor's claim, therefore that's a proprietor remedy and therefore you don't need to be registered. The second half talks about distribution to licensees, and that's a licensee remedy and therefore you do need to be registered. And that's how he approached the analysis. And then at Roman 3 he said that might not lead to overcompensation because it doesn't necessarily mean that the proprietor will get paid more. Now we say the judge was wrong and that the correct construction is that 25(3)(b) imposes a mandatory requirement of registration as a precondition to all of the protections under section 30, including the right to have a licensee's damages taken into account under section 36. This is for the following reasons, and in order, but there it is, I hope a logical order. First, section 25(3)(b), linguistically at least, is in broad, and we would say inclusive terms. A person claiming to be the licensee does not have the protection of section 30 or 31. And we say that means all of the protection in section 30 and 31, not limited to certain parts of those sections, as would be expected, we say, if the intention was to introduce a more nuanced analysis of section 30 and 31. You can have this section, but not that section. Second, we say, as confirmed by the parenthesis in 25(3)(b), section 30 and 31 are concerned with the rights and remedies of the licensee in relation to infringement. The rights of the proprietor are addressed elsewhere, specifically under section 14. Third, when properly understood, and that's the reason I treat your lordship first of all to section 30, section 30 provides a coherent waterfall of remedies within a self-contained structure, i.e. the right to request, which may lead to the proprietor's claim on behalf of a licensee or a licensee claim on his own behalf. And that is the correct context, we say, for consideration of section 36, which is ancillary to the procedures allowed for in the preceding sections. And the purpose of which, the clear purpose of which we submit, is to ensure that the claim by a proprietor on a licensee's behalf is complete.
Could we just look at 25(3)(b)?
Yes.
382. The part in parenthesis that you've just referred to,
yes.
It's not a reference to a title or a descriptor that's used within the Act itself. These are authentic words of that subsection, rights and remedies of licensee. It's not a quote from section 3031.
It's not a, no, it's not a, well, be careful to say, it's the actual words used in the section, yes, absolutely right.
Yeah.
And it's not a quote, if we can go to the actual sections themselves.
Before we leave that, the point I was first seeking to make is when seeing the parenthesis, I wondered whether that was simply lifting the title of the part that it was then going to. It isn't doing that. In fact, it's close. It's actually saying that you don't have the protection in relation as a licensee to rights and remedies.
Well, let's paraphrase it a little bit. My Lord, just as Arnold said, haven't lifted and dropped it, if you like.
Yes.
It's in the same territory, shall we say, but it's not an example.
No, exactly. But it's not. If I may, it's not a point against you. It's simply that it's describing in 25(3)(b) what it means to describe.
Yes,
it's
exactly.
not doing it elusively.
Exactly, my Lord. That we say that there's. I can't put the linguistic points too highly, but we say it is significant that it does that in that broad term.
Right. Sorry, you were going on.
Now, I was going on to my fourth point, which is that if within the structure that I've set out, the proprietor brings a claim on the licensee's behalf or in respect to the licensee's interests, it is to that extent acting essentially as a nominal or representative claimant to vindicate the licensee's rights, because that's what section 30 is about. I said earlier, the proprietor is able to vindicate its own rights pursuant to section 14 and to claim all its own losses under section 13. But there's nothing to suggest that section 36 should be read as standing as a sort of self-standing independent provision included to enable the proprietor to make recovery beyond its own loss. That's essentially the case I'm facing. In context, it's ancillary to what precedes it. It's not independent and self-standing. And it would be a radical, the case I'm facing, and essentially the judge's case, that this is a proprietor remedy and the proprietor can obtain these damages, would be, we say, a radical departure from, first of all, fundamental common law principles of compensatory loss, in which the proprietor can only recover for his own losses. It would be inconsistent with Section 14, which says his recovery should be the same as any other proprietary interest. It wouldn't be buried in a section overtly dealing with licensee rights, suddenly come up with a new remedy for proprietors' recovery of damages. And it would have to have some rationale. There have some reason why the proprietor could step in and bring a claim beyond its own loss, which hasn't ever been explained. So we say that the rationale of it, it's either ancillary to what precedes it, which makes full logical and commercial and legal sense, or it stands out as being independent and unusual and against all normal common law principles of damages, which doesn't make any sense. Fifth, and by the same token, the suggestion that Section 36 is a protection of the proprietor, whereas other parts of Section 30 are protection of the licensee, which is the judge's interpretation in the respondent's case, produces asymmetry in the section, leading to different outcomes for no rationale. So if a licensee brings his, so having made the request, if a licensee brings his own claim, he must be registered. Having made the request, if the proprietor chooses to bring the claim, he needn't be registered. What's the logic in that? None. That's my fifth point. Sixth point also produces an illogical contrast with Section 31. I say it, the judge's view and my friend's view, illogical contrast with Section 31. Now, Section 31, which I mentioned but didn't take you through in any great detail on paper 387, is the regime for qualifying exclusive licensees. And in short form, if it's a qualifying exclusive licensee, he may bring his own proceedings in any event. So there isn't the same structure. You don't need the structure for a request. You don't need the structure for the proprietor bringing a claim on his behalf, because the qualifying exclusive licensee can go straight there and make his own claim. That's what Section 31 allows him. There's no equivalent in Section 31 to Section 36. So on the judge's interpretation and my friend's interpretation, if the proprietor has a non-exclusive license, he may get all the benefit of Section 36. He may claim damages beyond his own loss, because on that case, Section 36 gives that to it. If he is an exclusive licensee, he can't. He can't claim this great remedy, apparently sitting buried in Section 36, for a non-exclusive license, if he has the misfortune to have an exclusive license. It doesn't make any sense. There's an asymmetry, again, between the remedies available to the proprietor. All of this pointing to the conclusion we say, this is plainly a licensee protection about licensees' losses, and it's simply the route by which they are achieved, not a proprietor remedy. And seventh point, we say that interpretation, which is also, we say, the natural interpretation, is consistent with the legislative policy of encouraging registration by ensuring that all licensee remedies require prior registration, such that any remedy which doesn't require registration, in my learned friend's case, erodes that policy and creates inconsistencies. Now, the policy in favour of registration, I have to be a little bit careful because I know the tribunal has much more familiarity with this than me, but the policy was reflected as early as 1938 in the original Act, which we have in the bundle, Authorities, tab 16, paper 398.
Well, does the 1938 Act really shed much light, given that the whole point of the 1994 Act was to sweep it away and start again?
Well, only to say this, my lord, because there is a continuity. If you give me two minutes, please. 398. The original 1938 Act, 28 registered users. That was the terminology concerned for licensees at the time, and the right under Section 28(3) was a right subject to any agreement subsisting between the parties. A registered user, that's but in our language, a registered licensee of a trademark shall be entitled to call upon the proprietor to take proceedings to prevent infringement. And if the proprietor refuses or neglects to do so within 2 months after being called upon, the registered user may institute proceedings for infringement in his own name, as if he were the proprietor making the proprietary defendant. So, yes, things have moved on, but one can see the acorn of the structure in the 1938 Act, limited as it was to registered user / licensees. There's no equivalent to Section 36, and it may well be this logical gap hadn't been thought of at the time, and therefore it wasn't one that needed to be plugged. But the structure at the time was there was a remedy available, but only to a registered user. Now, and that, we say, reflected a policy in favour of registration, you can see in the section, and that was continued, and this is where there is a continuity, into the 1994 Act. And one can see that from the DTI report preceding the 1994 Act, which is Authorities tab 22, page 441.
To be precise, this is the white paper.
This is the white paper, yes. This is the white paper in advance of the Act, and on paper 441, paragraph 438, provision of the present law for recording registered users is not mandatory. It's thought that many licensing arrangements are not...
Sorry, which page you want?
441 paper.
441.
438, not recorded. The Mathis report suggests that proprietors should be required to register all licenses. Government's view of the question of whether to register a license should be a matter for parties, which is fine. In any case, nonetheless, the majority of the Standing Advisory Committee considers that the recording of licenses should be encouraged in the interest of legal transparency. It will therefore continue to be the case that only a registered licensee will have the right to bring an action for infringement. So it's the continuity from the 1938 Act. The law will also make clear that an unregistered license has no legal effect vis-à-vis third parties. So, for example, a person acquiring a trademark will not be bound by a license of which he was unaware. The simplification of the procedure should encourage the recording of licenses and may even lead to many of the presently unrecorded licenses being registered. So the policy in favour of the 1994 Act swept away much of the 1938 Act, but the underlying policy in favour of registration was not swept away, but indeed, we say, repeated. Now, the same policy, I'm just going to mention this, I may have to come back to this in reply, in the notes on clauses. Now, there's an issue about admissibility of the notes on clauses, which I'm going to have to deal with, I say, in reply. But can I just show you what the notes on clauses say in relation to this? Because it's a reflection of the same policy in the white paper. And if we go to 25, tab 25, paper 479, notes on clauses for the bill, and the relevant section at 491, the wording that the ordering had changed, it was section 22 at the time. 22, 3/4 of the way down, paragraph 8, subsection 3b, that's our 25 3b, as is now, provides that a person claiming to be a licensee does not have the protection of 2728, our now 3031, and an application is made to register. Thus, the holder of an unregistered license cannot sue for infringement or call upon the proprietor to sue on his behalf, nor can any loss sustained by him be taken into consideration in assessing damages where the proprietor has brought infringement proceedings. The justification of this provision is that a person should not be liable to be sued or have to pay damages to another person when he had no way of knowing that that person had any rights to which he was infringing. The provision should encourage the registration of licenses so that the interested public can be aware of the true position as to who has rights under a registered trademark. So I'll come back to the admissibility issue, but the same policy reflected here as in the white paper in favour of registration is a policy we say which is consistent with our interpretation and not consistent with the respondents' interpretation because of the gaps which they create. That's the policy. Equally, and it's my eighth and last point, is that we say our interpretation is consistent with the promotion of fair and efficient litigation. Basic principle of fairness, that claims should be articulated and certain at the earliest opportunity, and that a defendant should be able to understand the nature and scope of the claim which it has to face. A claim made by a proprietor for its losses may be very different, and indeed in this case is very different from a claim made by a proprietor for a licensee's losses. And a prior requirement of registration provides primary validity of a licensee's claims to those losses. So the true scope and validity of any claim and the value of any claim can be understood and dealt with in an orderly way in the litigation. That's a policy which is wholly ignored, we submit, by the respondents' analysis. And indeed, it's worse than that. If one goes back to the core bundle, tab 6, page 75. Which is another friend's skeleton. And paragraph 39.3, it says the purpose of registration of licenses can be inferred from the Act is only where a license is registered that a non-exclusive licensee might, in place of the proprietor, bring infringement proceedings, refers to 33, which is correct. The registration of a non-exclusive license is needed so that an alleged infringer can understand the basis of which someone other than the proprietor is bringing infringement proceedings against it. Now, we agree with the sentiment. It applies just as much to Section 36. They must be registered. They must, on the respondent's case, they must be registered before they can bring their own claim, because that's needed so the defendant understands the basis of the claim being made. Absolutely the same for Section 36. They must be registered so that the defendant knows what damages claims he's actually facing. And as we see in this case, 80% of these claims are in respect of unregistered losses.
But the claim's brought by the proprietor.
The claim is by the proprietor.
And it, from the outset, not this case, I know, but from the outset makes it clear that he's recovering losses from other licensees. You do know what claim you're facing. Why does registration make any difference to that?
Well, registration, first of all, it puts it on the register. There's no doubt about what the license is. The section provides that needs, there's no doubt that the section provides that that's needed if a licensee makes the claim.
Uh-huh.
So it's the same rationale. The proprietor makes the claim in respect to the licensee losses. The same rationale applies, one as to the other. There's no distinction between the two from the defendant's point of view. The name of the claimant changes, but the claims are the same. Reverting to the judge's analysis in the core bundle, page 104, there's really a single point in the judgment that we looked at, which is that because the proprietor is the claimant, this is a proprietor claim, a proprietor remedy. And it's not a protection of the licensee. And we say that misunderstands the structure and purpose of the section, as I've taken you to. At 53, the judge says it's to avoid a black hole, where there's a disconnect between the party asserting the right and the party incurring the loss. We agree with the stated purpose. It is to avoid a black hole, but it doesn't support the conclusion because there's no black hole when the proprietor vindicates his own rights. That's section 14. There's no such black hole in a proprietor's claim. The black hole arises when the proprietor seeks to vindicate the licensee's rights. And that's why it's a licensee protection, not a proprietor protection. So the question is right, the answer is wrong. And the error, we say, is exacerbated in 55 because it cannot be a correct, with respect, interpretation of the section to divide it into two and say the first half is a proprietor remedy and the second half is a licensee remedy. Quite apart from the invidious outcome of that, which would encourage licensees not to register so they can then sweep the pot. One doesn't interpret statutes in such a way, we submit. It has to be interpreted as a whole. The fact that the last part of the section expressly refers to provision to licensees essentially indicates very clearly, we say, it's a licensee protection. Now, if we can go into Van Fran's skeleton, tab 6, page 65. And there are really 4 points identified at the top of the page, 10.1 to 10.4. And the first point, which is in many sense the principal point, which is repeated many times, is that section 36 is the mandatory terms. they shall be taken into account. And therefore it said the court is always obliged to take it into account whether the licensee is registered or not. We say this is a flawed exercise, that the exercise itself is flawed, because the question for the court is whether access to the benefit of Section 36 is precluded by Section 25(3)(b), where the license isn't registered. You can't answer that question just by looking at Section 36.
Right, so that the statement that it's mandatory begs the question.
Exactly. Or it's, as counsel are often going to say, and I was about to say, it assumes that it seeks to prove, i.e. that you're into Section 36 already. The question is, can they get into Section 36? You don't answer about that by looking at what Section 36 says. You have to look at it as a matter of construction as a whole. In context, we say Section 36 doesn't impose some freestanding compulsory obligation on the court to take into account licensee losses, as apparently alleged, in every claim brought by a proprietor. It would make no sense in the context of Section 30. There'd be no sense in the request, the process of proprietor claim, licensee claim, if in every single claim brought by a proprietor, the court had to take into account licensee losses. It would make no sense of Section 30. It would make no sense of Section 25(3)(b), because it certainly precludes a licensee, an unregistered licensee's claim. But that again would be meaningless if in every single case the court had to take into account licensee losses, because then you're simply cutting through Section 25(3) of it, B as well. And it is frankly absurd in the context of litigation that the court would be obliged to take into account losses even if not actually claimed, which is what their case is. So even if a proprietor claims for its own losses, as in this case, on the friends analysis, as I understand it, the court would be obliged to ignore the pleadings and say, well, we must take into account licensee losses because that's what the statute says. That can't be the right approach, we submit. The reality instead means that the mandatory words, mean is if this is a properly brought claim that entitles an examination under Section 36, then the court must take into account the losses. But that, as you say, that begs the question as to whether it's right or not. That's 10.1. 10.2, it said, well, 25(3)(b) operates to exclude a person claiming to be a licensee, lifestyle are not persons claiming to be licensees. That, I think, is just an error in the interpretation of the statute. Of course, the licensees, well, as far as we're aware, are claiming to be licensees. Section 25(3)(b) doesn't refer to the claimant in the proceedings. So if we go back to 25(3)(b), 25(3)(b), page 382. A person claiming to be a licensee does not have the protection of Section 30 or 31. I think the argument is, well, the claimant here is the proprietor, not the licensee. That is to misread this section. The section doesn't speak of who's claiming to be the claimant. The section says claiming to be a licensee, and one can see similar wording, 25(1)(a), a person claiming to be entitled to interest under a registered trademark. It's simply it's for identification purposes. Who is the person benefiting from this, not who is the claimant in the action, which is not what 25(3)(b) says. So 10.2, on the face of it, it's just wrong in the way it's described, but also, as we understand it, proceeds on the basis of misunderstanding of the statute. And 10.3, Section 30 is for the protection of licensees. The stipulation mandating that losses suffered or likely to be suffered by the licensees be taken into account when the proprietor brings a claim. And this is the, again, as we understand it, if you like, a core submission of the respondents accepted by the judge, that this is a protection of the proprietor, not a protection of the licensee. If one, still in this skeleton, go to page 72, paragraph 35, the respondents accept that Section 30 is largely directed at protection of licensees, but it's not limited to that. I.e., within a section otherwise concerned with the protection of licensees, in the respondent's case, a provision dealing with the recovery of licensee damages is somehow not also concerned with the protection of licensees. That's the logic of the argument, and we say it's obviously not right. And it's based, we say, on an error of analysis, because as is clear from the respondent's skeleton, as I mentioned a little bit earlier, they wish to characterize Section 36 as a means by which the proprietor vindicates its rights. Still in the skeleton, if one goes to page 69, and see how this is expressed, paragraph 21. Section 36 is a provision that is principally for the benefit of proprietors, consistent with it only applying in infringement proceedings brought by the proprietor. And then at page 72, paragraph 32, the specific provision skeleton interpretation of the judge is a charge of unjust enrichment is wrong. Section 36 prevents a proprietor being deprived on the basis that he exploits it in conjunction with another person of the correct measure of damage for the unlawful exploitation of its property right. And we say it's just wrong. That is fundamentally wrong. The proprietor is not deprived of anything in respect of its own loss. It can bring its full claim for its own loss under Section 14. This is not a section to give it an add-on beyond the entitlement to its own loss. It's not a protection to ensure the proprietor is deprived. It's a section to ensure the licensees get what they're entitled to.
Its loss in a particular case might include losses that are suffered in the first place by a licensee, where the licensee has a knock-on claim against the proprietor because of that, presumably. That would then be the proprietor's loss.
That would be the proprietor's loss, yes.
Yeah. It doesn't need Section 36 to deal with it.
No, under Section 14, that would come under that as well, because it's loss. So there's a fundamental misunderstanding, we submit, of what Section 36 is intended to do. It cannot be, as I said earlier, sort of self-standing supervision.
Because I mean, your argument, right or wrong, is that it's superfluous, it's needless.
And not just that, it would be wrong. It would be wrong if the court were mandated to give the proprietor damages beyond its own loss, which is the only thing in the reference case 36 could do. So that's why we say on issue 1 the judge was wrong. Issue 2, moving swiftly on, can the issue, if it's right that the registration, Section 36 requires registration, can that be cured either after the event or at any time until judgment? Going back to the judgment on page 106, paragraph 56, curing by late registration.
Yes, you mentioned issue 2. You're now on issue 3.
I did mention issue 2. I meant issue 3.
Yep.
It's ground 2 of the appeal.
Ground 2 of the...
Yes. I stand doubly corrected. Right. Issue 3, as the judge refers to it, curing by late registration. And what the judge does is he looks at 25(3)(c) and says it uses the word until. Until an application has been made, makes clear the time frame for an application to register is open-ended. That conclusion is reinforced by different terms of 25(4)(a), which uses the word unless, and therefore he answers that there's no time limit in which an application for registration needs to be made to obtain the protection of Section 30. So it's a linguistic answer by reference to the word until, in contrast to the word unless. Now, the conclusion as expressed by the judge, I can't think he actually meant that. There's no time limit. I'm not sure anyone was arguing for that. There must be some time limit on matters. And with our friend's case, if one just goes back to the skeleton on page 65, tab 6, paragraph 12, nothing prevents such applications being made. And Lifestyle says that can be done at any stage prior to the final order of the damages inquiry. So right up, as I understand it, right up until the judge is about to pronounce judgment, it can still be done on this case. And we say this, I mean, it just must be wrong. Reasons. First, 25(3)(b), it goes back to that, authorities hard copy 382, on any view, and I have to be right on issue 1 to get to issue 3 of course, but extends the protection or requires registration for the protection in 30 and 31. So it must operate, in terms of working out what it means, it must operate consistently in respect of all the protections in section 30 and 31. It can't operate differently with regard to different protections. Sections 30 and 31, as we've seen, provide a series of ways under which a licensee, or an exclusive licensee, is granted the means to vindicate his rights through legal proceedings. By requiring the proprietor to claim, by bringing claim, exclusive licensee to bring claim. If one applies 25(3)(b) to the simple case of a licensee bringing his own claim, then we say the application of the section is self-evident. You go to section 33, the licensee may bring his own claim, original section 33, in those circumstances. That's a protection of the licensee. The application of 25(3)(b) we would submit is that until the application to register is made, he can't bring the claim. But putting the two together as a matter, we say,
Can I just explore that? You started by saying, can you occur registration after the event?
Yeah.
I want to ask what the event is.
Well,
let's assume there's a license. That's stage one. Stage two, there's an infringement. And then after that, ceased, there's a registration.
well,
Can the licensee bring proceedings to claim damages for the infringement that occurred before it was registered?
that goes to 25(4). 25(4) is a substantive provision. In the original 25(4), the answer was no. In the new 25(4), the answer is yes, but he can't get his costs.
It doesn't answer the question.
It doesn't answer the question about proceedings.
It assumes.
The answer to the question is, I was about to try to get to the answer to the question is, that it's when the proceedings are brought. That's why I started with section 33. So under section 33, the licensee may bring his own proceedings. 25(3)(b) says, you don't have that protection unless you're registered. We say putting the two together means you can't bring the proceedings and you can't exercise the right that section 30 gives you until you're registered.
So 36 does have retrospective effect to this extent, that in the same scenario, there's a license, then there's infringement, then there's registration. The proprietor could bring proceedings and bring in the licensee's losses under 36 in that case.
Yes, section 25(3)(b), as we analyse it, doesn't affect the substantive rights about pre-registration losses, post-registration losses, that's 25(4). 25(3)(b) is concerned with the process in section 30 and 31. You can't bring the claim unless you're registered. And let's say, so I was trying to start it with section 33, the simple case, the licensee's own claim. If 25(3)(b) means anything, you can't have that protection until you're registered. It means you can't bring the process which section 30 allows you to bring until you're registered. Now, and that doesn't allow for late cure. You can't bring the proceedings and then do it 3 years later.
Could you not amend? If you did cure it later, could you not amend the proceedings at that stage?
Well, to do what?
To bring in the claim on behalf of the licensee.
You could maybe bring different proceedings, I suppose, if you're in time. We're not here, of course, but you could maybe bring in different proceedings. But if it means anything, the proceedings you brought are proceedings to which you are not entitled to bring because you are not registered, which is the precondition to bring in the proceedings.
Right. So if it is a precondition to bring in proceedings, as you say, if you got it wrong first time around, you could then register and bring new proceedings, provided you were within a time.
Yes, exactly. You could do that, exactly. You could, of course you could register any time, but you could register qualified to be entitled to bring the proceedings and bring the proceedings. Now, your Lordship said, could you amend? Who knows the answer to that question, give or take a little bit. But you could certainly bring new proceedings. The other proceedings hadn't been terminated, and you're within the limitation period, because you would then be able to bring those proceedings, and your entitlement to pre-registration losses would be fine under section 25(4), as that is. But it's a mechanism for the process, is how one interprets we submit 25(3)(b).
You said a moment ago registration was a precondition to bring the proceedings, but I think in fact you accept it's the application for registration.
Well, in all my assignment, I'm misstating something. Absolutely right. The date is the date of application.
Yeah.
So everything the same, but that's the date. So you must apply for registration, and once you've applied for registration, you can bring the proceedings. That's, we say, the interaction of the two. What it doesn't mean is you can bring the proceedings without registration. At some stage, a minute before judgment, apply.
What's the difference between application for registration and registration in terms of transparency? I mean, do people know when an application has been made in the same way as they might know that a right has been registered?
I'm sure I'm the wrong person to answer that.
Well, it's a matter of registry practice. I think the answer is one would have to look at the rules to be sure, but my recollection is certainly it used to be no. Whether that's currently the case, I don't know. But it used to be the case that you wouldn't know until it went on the register.
What we do, I'm grateful for that, what we do know in this case, of course, is that they applied to register the harvest license, seems to be very shortly before the hearing date. And there was a letter which was then produced shortly after the hearing date, which indicated that the application had been accepted.
Well, it's pretty quick these days because they don't examine the license. I mean, there used to be a delay under the 1938 Act because they would scrutinise the registered user agreement substantively, whereas now it's a formalities process.
So it may well be the answer. There's a short period of time between the two. I don't know. But
Right, well, so the idea of application being the important thing may be a holdover from the time when it took a long time. Whereas now it might be a very short gap between the two.
It may be, but in practical terms, if I'm right on my interpretation, it wouldn't really, certainly if it's not a long time, it wouldn't matter. Because even if the application is made the day before the claim form is issued, by the time the proceedings are up and running, then...
Anyhow, this is protective of the licensee.
Yes.
Yeah, and the rationale is clear, namely the application date is under the control of the person applying, whereas the registration date is not. That's under the control of the registrar.
Yeah.
Thank you.
So I started with, if you like, the easy case. We submit section 33, a licensee's claim. We submit the application of the two sections. Means the application to register must be made before the proceedings are commenced. No difference applies. We submit section 36. If I'm right that it's a protection of the licensee, exactly the same interpretation can apply. i.e. the claim in which the licensee's losses are made must be a claim pre-application to post-application to register. One can't have a different application to section 36, just to section 33. It must be the same. There's no obvious sense in a last minute, one minute before judgment, cure-all under section 33. There's equally no sense for section 36 if I'm right that these are both provisions for the vindication of the licensee's remedies and the licensee's rights. And that, we say, is consistent with the same history and policy in favour of registration, but also here also in favour of the efficient litigation. One has to just imagine what the consequences would be in this case, as apparently still maintained. For whatever reason, the claimants haven't registered all their licenses. They may or may not do so. We may get to the position, and there's been no indication that we won't get to the position, of a trial on liability, if your lordships are against me in the appeal, and then we still won't know whether they've been registered or not. We may get to a position, depending on what your lordships decide, that they have to register. We won't know if they will have satisfied that test by application, right up, and the judge won't know until he gives judgment. That can't be right.
No, later than that. It's the date the order is sealed.
I thought that.
I stand corrected again. One has to interpret this as a matter of common sense. Now, just going back to the judge's analysis, until paragraph 56, page 106, doesn't give you the answer. It is right that the word until is used in 25.3b, and what that means is that application to register can in fact be made at any time. So if you're a licensee, you can in fact register at any time. There's no limit on when you can apply to register. That's what until tells you. Until doesn't tell you anything about what happens until you do register, i.e. what rights you've lost until you register. So until doesn't give you the answer that the judge sought. It doesn't answer the question with respect at all. Equally, the contrast the judge raised with unless in 25.4 doesn't work either. In 25.4, there's a 6-month window in which application to register can be made. So there's a specific time limit within which all rights are obtained within the 6 minutes, the window. And that's why unless is used in 25.4, because there's that window. It doesn't draw any significance as far as until in 25.3b. So that doesn't work. And we say the judge also didn't follow through his own reasoning. If I showed you, Lordship, page 104, paragraph 50, the judge looked at section 36a, and that's a section for joinder, the new amended section allowing for joinder. And the judge says a licensee has no right to intervene in proceedings pursuant to section 38.
I beg your pardon, could you give me the reference
Sorry,
again?
page 104, paragraph 50. It's clear from the wording of the 1994 Act that until an application has been made for a sub-license to be registered under section 25, a licensee has no right to intervene in proceedings pursuant to section 36A. Correct. But he's applying what I say is the correct interpretation of the two sections. You can't avail yourself of the rights in section 30 until you've registered. He's not saying it doesn't matter if you don't do it by the time, because you always do it before the order is sealed. He's acknowledging, we submit the obvious interpretation of the section, is that the rights set out in 30 and 31 require an application to register to have been made. He doesn't then follow through the logic in his analysis when he deals with our timing point. Because when he deals with our timing point, he says the word until means you can do it at any time. So there's an inconsistency in his analysis which doesn't work. And we do say this analysis does undermine, your Lordship has the point, the fair conduct of litigation and the efficient conduct of litigation. And the present case is a very good exemplar of why this can't be the interpretation of the statute. As I've said earlier, Your Lordship, where it's a claim for claimant's loss of 1.4 million, they've sought to include licensees' losses of up to 6.3 million, didn't register any licenses at the time, have since registered one, have not said they've identified all the licenses, have not even said they will register any more licenses.
Well, their policy is to keep them confidential.
Oh yeah, apparently. So
it's not accidental, it's deliberate.
Well, yes. And the true scope of this claim, therefore, remains wholly uncertain. If I'm right on point number one, that this is a licensee protection and therefore registration is required, the true scope of this claim remains uncertain. It was uncertain before the judge, it's uncertain now, it will be uncertain, apparently, all the way to judgment, by way of deliberate choice.
The point, as I understand you to make it, is that, as so far found, the effect of registering or applying to register a license becomes a purely, it's an empty act. It's just something that is done. It takes no more than, no doubt, filling in a form and sending it off. It's done at a time of a particular party's choosing for whatever motives they may have in the particular circumstances. But in a sense, it has profound consequences. But it has no link to any infringement or anything of the kind. It's a purely formal step.
It's an entirely toothless requirement. Section 25.3 is entirely toothless if it can be satisfied at any time. But it's worse than that. It's not just useless. It is positively dangerous because it encourages a proprietor not to license, not to register as licensees, encourages a proprietor not to tell the defendant what the position is, encourages a proprietor to keep these matters open and therefore the scope of the claim to be uncertain all the way through. So it encourages tactical manoeuvrings and encourages trial by ambush, because even though that 6.3 million figure is on the face of the pleadings, is it a real figure or not? Nobody knows, by reason of their choice. So it's toothless, but it's worse than toothless. It's positively dangerous. And the court should have no sympathy. One of the submissions made is that this would be very unfair if the section were interpreted in the way we've said it should be interpreted, because the proprietor could lose out. Lord, first of all, the proprietor won't lose out in respect of his own damages, but the court can have no sympathy, we submit, with the situation that's now arisen. It's entirely in the claimant's control. It's entirely their decision throughout. They've chosen to proceed in this action in this way and to disadvantage the defendants. And the reality, going back to my friend, my Lord Justice, Zacaroli said, had they been within time, they could have solved the problem. Had they been within the Limitation Act, this problem could have gone away if they'd chosen to register a license, to apply to register, and either to start again or to try to amend to include. but we're well beyond the limitation period now. So that avenue isn't open to them. This is a case which has run out of time a long time ago. So for those reasons, my lord, and a bit of a gamble, I'm afraid, but those are my positions.
No. Thank you very much indeed, Mr. Beltrami. Yes, Mr. Zacaroli.
My Lords, I was going to structure my submissions in response, obviously subject to your Lordships, in the following way. I was going to deal quite briefly with some questions of law that arise first. Then, secondly, the basis of the damages claim. Thirdly, then into the grounds. Thirdly, the first ground. And I don't think I'll outline now for you how I'll address that. And then, of course, the second ground after that. A lot of my learned friends' submissions are points that aren't covered in the skeleton argument that's filed on behalf of the appellant. I mention that simply on the basis that that might mean some of my structure is a little bit haphazard as I try to weave in those points in the course of my submissions. So first of all, my Lord, some questions on the law. We've addressed statutory interpretation in my skeleton argument. I don't think that's something that I need to dwell on with your Lordships, but the relevant approaches are set out. Secondly, there was an issue in my skeleton argument about the relevance of parliamentary debates, but you haven't been taken to any parliamentary debates, so I don't address you on that either. There is then the point that my learned friend mentioned he'll deal with once I've made my submissions to you in reply, which is about the notes on clauses.
Can we, just before we leave the parliamentary debates, I mean, I noticed in passing that there'd been reference made to them. I couldn't understand what they were doing as part of our case, and it doesn't appear that either party is now seeking to refer to them.
No, my Lord. I mean, I understand that they were included as part of the indications of what the legislative
Well, I understand why
history
they're included, but I mean, I didn't understand how they in any way crossed the threshold for consideration here.
No, well, no, it was my position that they didn't, and you haven't heard submissions to the contrary.
No, there was a bit of a crossover between council, etc. I'm not putting forward any case based on the
Right, common ground. We don't look at it.
Yes.
Not the bill, the hands-on stuff.
Yes. So I understand what's happened is that my learned friend now relies on the white paper, which wasn't mentioned in the skeleton argument, but and it's not in dispute that the white paper is something you can look at for the purposes of background. So that's the end of that potential issue. So the notes on clauses, my Lords. I think you were provided yesterday electronically with a copy of a case from this court in 2024 called Shahabi and the Kingdom of Bahrain. I've got some hard copies of it as well, if that's useful to you.
Yes, please.
So there are 3 copies. It may be three of the same. So this has had some numbers applied, so it could go at the back of the existing hard copy bundle. Of course, my Lord Justice Jackson, I think you have it electronically.
Yes, I have.
I think that's also the case for this one. So on the relevant passage begins on page 521 of the report. So in the hard copy numbering at the bottom, that's 533. But it's paragraph 57 of the judgment here. The context of this claim, just to explain, was about a question of state immunity. So you'll see the heading just above paragraph 57, which is Article 11 of the ECSI, so that's the European Convention on State Immunity. But for today's purposes, the only the particular features of that aren't relevant. But at C, on the left-hand side, there's a sentence that begins, "He relied also." And this is the introduction to the notes on clauses that were referred to in that case. So he relied on what are described as notes on clauses provided to ministers during the report stage of the passage of the State Immunity Bill in the House of Lords. So that sets the context. And then I won't take you through the rest of that paragraph 57 and the quote or paragraph 58 because they're particular to that case, but of relevance paragraphs 59 to 61, which explain why the notes on clauses are not admissible as matters to assist in statutory construction. So 59 begins more fundamentally. It may be the simplest way, my lords, is if I could just ask you briefly to read from 59 to the end of 61. And I'll make short submissions on those points.
Yes.
So, my lords, paragraph 59 adopts the judgment of Mr. Justice Sales, as he then was, in the Public Commercial Services Union case. There is, in my submission in that extract, you see beneath paragraph 59 a clear and binary statement that notes on clauses are not admissible. That is the case whether or not the notes on clauses were either only available to a small number of people or were slightly more broadly circulated to members of Parliament. But in both cases, it was Mr. Justice Sales' position, as adopted by the Court of Appeal here, that those notes and clauses, because they were not available to members of the public generally, couldn't be taken into account as matters.
Well, I mean, I think we end up in roughly the same place, but the Supreme Court doesn't seem to be saying quite the same thing as this court in relation to those matters.
So, my lord, yes, you see that in 60.
Yes.
So the Scottish case. Now, in that, the very last sentence of the preamble to 60 before the quote indicates that the notes in that case were published both online and hard copy. So they were published, they were available to members of the public, whereas the situation that Mr. Justice Sales was dealing with was ones where they were only sort of privately available in Parliament. And my understanding is, in respect of these notes on clauses, is that they are only available currently in the House of Commons library, perhaps the House of Lords library, at least the parliamentary library. And they're materials that my learned friend and his team have uncovered and provided. So that they fall into Mr. Justice Sales's category, not into the Supreme Court's category that's dealing with something slightly different. So, in my submission, these are materials that the Court more than isn't entitled to rely on in its proper approach. Even if they did fall into the Supreme Court's category in 60, then there is a strong indication that very little, if any weight, should be provided to them on the basis that they are not parliamentary materials. They are a view taken on clauses. So, one final thing I should say about this. This Shahabi case has been appealed to the Supreme Court. The oral hearing was in November of last year. Judgment is awaited, but it's not clear that, wasn't clear to me at least, that this was part of the appeal. So that's the position on notes on clauses. The final aspect of the law I wanted to mention briefly was the reliance placed on the apologies, there are two areas of the law, apologies. The first is reliance placed on the enforcement directive to some extent in at least my own friend's skeleton, and mentioned today in the context of its effect in leading to the amendment of section 25. So you were told by my learned friend today, and this is common ground, that section 25(4) was amended so that its previous prohibition on the recovery of damages was deleted and replaced only with a limitation on the costs that can be recovered where a party is a proprietor, become proprietor and hasn't registered that before the infringements take place, or is a licensee and hasn't registered their license before the infringements take place. And in my submission, that has some relevance when we come to look at the second ground and the approach that's taken to that. It's also perhaps relevant to mention that the enforcement directive, to the extent it may be relied on to indicate the approach that one should take to interpreting Section 30, doesn't provide any limitation on the scope of a damages inquiry that the court can consider. It is it's a directive that sets a minimum standard, so member states are always entitled to provide for more. But it does provide that essentially an unlimited inquiry to the assessment of damages is only limited by taking into account things that are appropriate, and they include negative economic consequences and also potentially profits made by the infringer. Then the final point of law is which version of the Act one ought to have in mind for the purposes of this analysis. And I think it's now common ground that, and it certainly was my position in my skeleton, that the correct version of the statutory materials that are before you to look at are the ones that were in force at the time of the infringement. And so they are Section 25 with that amendment that I've just mentioned, but Section 30 before the addition of sections.
Say that again, I'm sorry. There's a little bit of background noise. It's
Apologies.
hard to hear.
Apologies. My proposition is that the correct version of the statutory materials is those that were in force at the time of the infringements.
Yes.
So that was between 2014 and 2016. So that means it's the version of Section 25 that is as amended, because those amendments took place in 2006, but the version of Section 30 prior to its most recent amendments, because those took place later.
Thank you.
The next topic to address is the basis of the damages claim. My learned friend has already taken you to this to some extent, but there are two factors about it that I think ought to be either repeated or made clear to your lordships. So the damages claim, as my learned friend, I'll take you to the points of claim if I may. So it's the core bundle, tab 15 and page 192 is where it commences. The relevant, or particularly relevant part for my submissions is paragraph 17, which begins, or is on page 195, and that sets out essentially four heads under which damages are sought in these points of claim. So the first 17.1 is the loss of direct benefit from the sales of legitimate, or would-be sales of legitimate Beverly Hills Polo Club goods that would have been made but for the defendant's acts of infringement. Then there is 17.2, the loss of revenue that resulted from the presence of the infringing Beverly Hills Polo Club goods in the defendant's channels of commerce. Now, those are the only aspects of the damages claim which are touched upon by these the matters that are before your lordships. So I concentrate on those. They cover different time periods. So section 17.1 is a complaint about the direct impact of the sales made by the defendants of the infringing goods when they were taking place. So they took place between 2014 and 2016, and 17.1 deals with the consequences of that for what were my clients' then licensees. Those licensees were not ones subject to, So those licensees existed, and the proposition is that they lost sales as a consequence of the sales being made by the defendants. 17.2 is a different claim. This results from what I would describe as the long shadow of the infringements. So whilst the infringement took place between 2014 and 2016 and stopped in 2016, my clients complain about the continuing effect of those infringements afterwards. And I draw attention to this because it's relevant in respect of the date on which the harvest license was entered into. So the harvest license was entered into in 2017, which is after all of the infringements had taken place. So in my submission, the correct analysis of the allegation of damages, summarised under 17.2, is that what it really seeks to claim is the damage, the loss of the value of my client's property rights in its trademarks as a consequence of the infringements which took place between 2015 and 2016. But that loss meant, or the consequence of those infringements were, that property right was less valuable as a means of, could be exploited in a less valuable way. Now, the way in which that diminution in value manifested itself was because by 2017, Harvest had become the exclusive licensee for at least sales and promotion in the United Kingdom. It was Harvest that immediately felt the pinch of that, but it was a measure of my client's diminution that it suffered in the value of its...
So Harvest was an exclusive license?
So, yes, I should be clear about it, my lord. It is exclusive in the sense that Harvest was entitled to do certain things to the exclusion of all others. It isn't an exclusive, what my learned friend referred to neatly as a qualifying exclusive license. So an exclusive license that falls within section 31, which permits the exclusive license to be treated as the proprietor.
Right, so there can be other harvests. There can be other people in Harvest's position. With their own different...
Well, no, my lord. Because Harvest was exclusive in respect of sales and promotion and various other things, it was the only person who could be licensed to do those things. But it wasn't an exclusive license that fell within section 31.
Where is Harvest pleaded in these amended particulars of claim?
In the amended particulars of claim,
Points
of claim. Harvest.
let's start taking the stages. Is it mentioned by name at all?
Yes, my lord. Yes.
Where?
One particular place, so that this isn't the first, is in the section that begins at paragraph 31.
All right, well, before we get there, I hadn't realised it was that far wrong. Could we just pick up paragraph 20?
My lord, yes.
Where we see claimants seek in this claim recovery of
Yes.
losses made by claimants' licensees
Yes.
under section 30, subsection 6. So it's an explicit claim in respect of losses made by the licensees, not by the claimant.
My lord, that is correct. That is in respect of the damages that fall under the summary in 17.1, which are, as I described them, those losses that directly resulted between 2014 and 2016 from the sales of the infringing goods. So this is the section that begins above paragraph 18, direct loss of sales. So it's the allegation that there are losses.
These are the 17.1 points.
My lord, yes.
Which isn't Harvest.
Which isn't Harvest, my lord, no. So it's the section that begins loss of revenue above paragraph 22, which covers the losses where I say Harvest felt the pinch first.
The 17.2.
Correct, my lord. And in general terms, the allegation is that what happened was that because of we might phrase it without meaning this to sound pejorative, but pollution of the market by the existence of the infringing goods, and particularly the infringing goods we say sold at heavy discounts, that when my clients, through their licensee Harvest, came to speak to UK retailers with the hope and expectation that they would take and sell garments bearing my client's logo, that the discussions got to some advanced stage, and then in the two instances that are pleaded expressly in
All right, so moving through, we see again 24 again the claim in respect of licensees' losses under 30 subsection 6, and then further alternative, claimant suffered losses through reduced license fees, so that's claimant's own losses. And then you were referring us to paragraph 31, I think.
Yes, it's the,
where Harvest is mentioned.
my lord.
But where does it say that Harvest was a licensee, let alone an exclusive licensee?
Well, in the preamble of 31, it indicates the claimants through a licensee but engaged in discussions with potential retailers.
So we join the dots,
yes.
Even though it's not expressly stated, and divine that Harvest is a licensee.
My lord, yes,
And
that's
where is the license pleaded?
the license, I don't believe, is paragraph 64.
Well, before we get to that, can I just ask you about paragraph 43 and following? We have a licensee of the claimant's licensee A, and apparently the identity of licensee A is confidential.
My lord, yes.
Is that still the case today?
I don't have an answer directly for you, my lord. Perhaps not.
Right. Okay. But certainly, as at this document, date of this document, one would take it that that was an unregistered license, because
yes, my lord, yes.
If it was on the public register, there could be no basis for the claim to confidentiality.
Correct, yes.
And we understand it's your client's policy to keep the identity of its licensees confidential.
Yes, that is its stated preference in the evidence that my learned friend took you to.
So it's a deliberate policy of non-registration.
To that extent, my lord, that is characterisation I can't dispute.
Okay, thank you.
The point that arises from this, my lord, is that the Harvest licence, whilst it resulted in damages, was something that was entered into after the claim was brought.
Paragraph 64.
Sorry, I was going to, yes, I was
going
going
to get
that
that.
one. Yes, so paragraph 64 does expressly refer to the licence agreement with Harvest.
Thank you.
It was entered into with the second claimant.
So one would assume, reading this, that Harvest is different to licensee A.
My lord, yes.
Thank you.
Yes, and so that licence with Harvest was entered into after the infringements were completed and entered into after the proceedings had been brought. And so the circumstances of the damages that are alleged to arise in this case are such that my learned friend's proposition that one can't bring a claim in respect of licensees' losses unless the licence has been registered before the claim is issued, leads to a position where my client would never be able to claim a Harvest licence.
Sorry, I need to understand that more loudly and clearly.
Yes. I think my learned friend's principal position in respect of the date on which one has to register a licence for the purposes of issue 3 ground 2, the curability point, as I understand it, is that one has to register the licence before commencing proceedings. And my learned friend says that applies to every aspect of section 30. But
we're talking here about you trying to reclaim Harvest losses in these proceedings. But there would be nothing to stop Harvest issuing their own proceedings.
my lord, there would be
Sorry, I had a question mark at the end of
Yes.
it, because I don't know.
Yeah, my submission, yes, there would be. Harvest couldn't bring its own proceedings because it doesn't have it doesn't have the right to bring its own proceedings under the Act.
Because it's a non-qualifying exclusive licensee.
It's a non-qualifying exclusive licensee. It could only act if my clients, the proprietor, had not brought an action. But in circumstances where my clients, the proprietor, had brought an action, then Harvest can only obtain recompense through the well, at least in respect of the statute as it existed at the date when the infringement took place, and indeed when Harvest's licence was entered into. Harvest could only receive recompense through the court's discretionary approach in the second part of section 30, subsection 6.
Well, Harvest couldn't bring its own proceedings under the current section 30 at all.
No,
Even irrespective of
that's also the case, my lord.
yes.
Because it's limited in a different way than the previous section subsection, the previous section 30.
Right, and could you, I know it's been explained already, but for my benefit, non-qualifying,
Yes.
meaning exactly...
So the straightforward way, my lord, maybe to take you to the Act. So you've got it in the authorities bundle at tab 15, which is in the first binder in hard copies, and then section 31 is on page 387, paper numbering. And you get an indication of what it's about by the heading, exclusive licensee having rights and remedies of assignee.
Just a moment. Sorry. Section 31, yes.
Yes, and so this is unamended, so the same draft applies throughout. But it relates, again, as one sees from section 31(1) as well, to exclusive licenses that may provide that the licensee shall have, to such extent as may be provided by the license of the same rights and remedies.
So by virtue of the terms of the licence,
yes,
the licence with Harvest could have given Harvest its own right to sue, but it doesn't.
But it doesn't.
So these are licenses where you effectively step into the shoes.
Essentially so, my lord.
Yes.
Yes.
But that's not Harvest.
That's not Harvest, no. Yes, so that isn't this case, so it doesn't apply.
So we dealt with Harvest being unable to bring its own claim, but I think your proposition was that on Mr. Beltrami's case,
Yes.
the claim by the proprietor could never include Harvest's losses in this case.
It's certainly not when
Why could it never include?
Well, so my learned friend's primary proposition, as I understood it, was that it had to be registered by the time of the issue of the claim. And because the issue of the claim took place before the licence even came into existence, then that couldn't happen.
Well, in this case, but a new claim could be begun later, I think he accepted.
Well, so yes, but a new claim by whom? Not by Harvest, because it doesn't have the right. Well, unless my client were to discontinue.
Yeah, let's assume it does that. So let's assume that it discontinues. It starts a new claim.
Yes. Well, then, so okay. So
within the limitation period, if that's...
Yes. So in that circumstance, then yes, that could work. You could discontinue. The old claim goes away. You start again.
Sorry, why would you need to discontinue? Why not have parallel claims and consolidate?
Well,
so that's what one used to do with regard to secondary infringement of copyright. There was an issue about whether the requisite knowledge or reason for belief arose. You'd issue a second writ in those days and then subsequently claim form and consolidate. And say, well, if I fail on date 1, I win on date 2.
Well, my lord, that the difficulty I have with that is that the pleaded case in the particulars of claim would be in respect of the same acts of infringement and the same
But so what?
claims. Well, the so what, my lord, is that then the court is faced with a multiplicity of claims.
But that's why you consolidate them
So
into one set of proceedings.
Well, so that may be a different procedural mechanism to achieve the same outcome. But in my submission, that we'll look at the sections, of course, in detail shortly. That in my submission can't have been what the sections were intended to.
No, but are you standing by your submission that Harvest couldn't recover?
Couldn't bring its own claim.
Well, or couldn't, by one means or another, protect its interests?
Well,
I mean, are we talking about the by one means or another here?
well, my lord, it's my proposition that Harvest's route is through the second part of section 30, subsection 6. So the proprietor has to bring the claim. The proprietor.
No, I was in the world where Mr. Beltrami was right and the judge was wrong.
Yes.
And I understood your position to be, well, that leaves somebody in the position of Harvest without a remedy. Does that remain your position?
Without a remedy that it could obtain by bringing its own proceedings, as the statute stood at the time of the infringement.
But you would have had a remedy, I think you're accepting, if a claim was brought sufficiently quickly by the claimants seeking to recover those damages.
It would be able to rely on section 30, subsection 6, the second part, where the damages it suffered are taken into account, and the court then exercises a discretion as to what happens to those damages.
Yeah, so I mean, the Harvest licence is shortly after the infringing events, 2016, late 2016.
Yes.
So imagine that a claim is brought by the claimants in 2017, claiming losses on behalf of Harvest, after having applied to register, of course. So in those circumstances, no limitation problem, and no problem with the claimants recovering on behalf of Harvest in that scenario.
My lord, yes, you put it to me today, I don't see a reason that wouldn't work. But it still is the proprietor, my client's, bringing the claim.
To be sure.
Unless I can assist you further, my lords, on the basis of the damages claim, that's how it arises, and why I say that chronology is relevant to the analysis you're being asked to undertake. So then I'll turn to the first ground. Now, my learned friend, before I go into the sections in detail, my learned friend's taken you to some of the background material, particularly, well, in fact, only to the white paper, and also to the notes of clauses, but in my submission, those aren't matters to which you should pay any attention. If I may return to the white paper just by way of background. So you have that tab 22 of the authorities bundle, so it's the second tab, and then the relevant part of it is the passage you were taken to by my learned friend on page 441. It's paragraph 4.38. And that, as my learned friend indicated, shows in my submission the background to the Act was the previous Act, 1938 Act, had for the first time in trademarks legislation permitted licensees to be registered. That followed from a situation where licenses were at least treated with suspicion. The intention, as recorded in the white paper at least, was that registrations would still be possible, but with a very simplified procedure, and that they would not be mandatory. And there's the sentence my learned friend read to you, which is in the middle of that paragraph. Nonetheless, the majority of the Standing Advisory Committee on Intellectual Property considers that the recording of licenses should be encouraged in the interests of legal transparency. And that, in my submission, that's the height of the background motivation for the licensing regime, such as it is that there was a majority, so not even a unanimity of the Standing Committee, that there should be some encouragement of licensing. And I draw your attention to that one because in my submission it's indicative of only requiring the barest nudge towards licensing to be something that results from the relevant statutory provisions for that objective to be satisfied. It doesn't require any significant adverse consequences to be visited on unregistered licensees in order to give rise to such encouragement.
It will therefore continue to be the case that only a registered licence will have the right to bring an action for infringement. So, I mean, that's pretty severe consequences, isn't it?
Well, I was going to go on, my lord, to say, when the Act does visit consequences, it says so expressly what they are. And that, in my submission, is one of those, that right to bring proceedings, and as you'd note, as I'm sure you would have done, carried on through that emboldened section, that the consequences essentially of section 25(3)(a), i.e. that one of the consequences of that section is that a later acquirer of a trademark may not be bound by a licence that isn't registered. That's again something that's expressly identified in the Act. So, my lords, that deals with the, to the extent that it's relevant to my submission, the background. I then go into the provisions themselves, which of course will take up take the real focus of your lordship's analysis. I was going to begin, if I may, with section 30 and section 36. The version that I say should be relied on, you've already seen, of course, but it's at Authorities 15, page 390. Apologies, section 30 is at page 390, section 30, subsection 6 is over the page on 391. And its relevant provisions in relevant contents in my submission. First, that it does expressly relate to infringement proceedings brought by the proprietor of a registered trademark. And I say that is significant, and I say that's significant for the same reason that the judge held it to be significant. In my submission, this subsection is dealing with proceedings brought by the proprietor. Carrying on through the section, it deals with any loss suffered or likely to be suffered by licensees, and requires expressly that such losses shall be taken into account. And as you're aware from...
Does that mean even if not pleaded?
My lord, it wouldn't mean that, but that's a matter of procedural law rather than substantive law. So, in all cases, the court will deal with the case put before it by the parties through their pleadings. And in my submission, despite a party having an entitlement to certain relief, if they do not seek it in their pleadings, then the court won't grant it to them. But in my submission, of course, in this case, there has been a pleading. My submission is that the appropriate place for any pleading of the calculation of damages is the points of claim when the inquiry as to damages gets underway. So in my submission, that first part of section 30, subsection 6, does indicate a mandatory approach when sought by a party where the court must take into account losses suffered or likely to be suffered by licensees.
Would you accept, we understand, shall be taken into account when properly claimed?
My Lord, yes, that's consistent with the submission I've made. I qualify that by saying that when properly claimed is when pleaded in the points of claim. Then the section has a semicolon. And in my submission, put very much weight on the punctuation, but that has some significance in that it indicates a break in this subsection. It indicates a separation in my submission between what goes in the first half, as I'll call it, and in the second half. The first half being, in my submission, mandatory and declarative of the approach that the court must take, and then sets out a discretionary option for the court. The court may give such directions as it thinks fit as to the extent to which the plaintiff is to hold the proceedings of any pecuniary remedy on behalf of licensees. So, in my submission, that has a separate consequence. Once the court has gone through the mandatory, in my submission, approach of taking into account the losses to be suffered by licensees in reaching its damages calculation.
And do you accept the judge's view that the second half is for the protection of the licensee?
So, my Lord, it is something that can be protective of the licensee, but in my submission, because it is discretionary, it doesn't automatically result in protection of the licensee. And so...
Well, it's not for the protection of the proprietor, is it?
No, absolutely not. But in my submission, it still falls outside the clauses that are referred to in section 25(3)(b).
This provision, sub 6, might have appeared at section 14 as subsection 3, mightn't it?
So, my Lord, I
mean, if we see section 14, which is
yes,
short and sweet, another way of achieving what you're suggesting might have been to put it in 14 itself, might it not?
Another way
it
of
wouldn't
doing,
seem out of place there.
Well, my Lord, it would seem out of place to this extent. Section 14 is covering the generality, covering the position where the proprietor itself exploits its trademark rights, and exclusively itself exploits them. This group of sections, it's a point taken in my learned friend skeleton argument, this group of sections expressly deals with licensing. And so in my submission, it's not surprising that the instruction to the court about what it must do when calculating damages in circumstances where there is a licensee is something that appears in this section. So it's an addition in some special circumstances. I mean, they're not particularly, I'm not suggesting they're unusual, but they are different than the basic situation where the proprietor exploits the trademark only himself. So that's section 30, subsection 6 in isolation. The other crucial provision that interacts with it on my learned friend's case is 25(3)(b). Again, of course, you've been taken to that already, but it is set out on page 380 of the... I mean, actually, perhaps formally I should take to page 382, because that is the version of the section, although this subsection is unchanged. And that, again, just to go through its content, is drafted as until an application has been made for registration of the prescribed particulars of a registrable transaction. And of course, that is something that, in my submission, is most relevant to ground 2, but is expressly indicative of a situation that comes to an end when an application for, whatever is said in this subsection comes to an end when an application for registration is made. Then subsection B deals with a person claiming to be a licensee by virtue of the transaction. And again, my submission is that the judge was correct when he held that this claim does not encompass a person claiming to be a licensee, because the person seeking the relief in the points of claim, or the persons are the claimants who, for relevant purposes, are not licensees. And that is an indicator that a claim such as this brought by a trademark proprietor, when they are not put outside the scope of section 30 subsection
I understand
6.
the point made against you is that under B, the words "a person claiming to be a licensee by virtue of the transaction," that you're reading that as if that meant the claimant.
My lord, yes.
That is what you're doing.
I read it on that basis in conjunction with section 36, because section 36 deals with proceedings brought by the proprietor. And so in my submission, when one has proceedings brought by the proprietor, one is not looking at and does not find a person claiming to be the licensee who is seeking protection or seeking the protection of.
I'm sure I'm being dense here, I'm not following. So the words we're looking at are a person claiming to be a licensee.
Yes.
That's not a reference, is it, to a person claiming a remedy in court?
Well, in my submission, it may not be within that section by itself, but when one is seeking to explore the interaction between this subsection and section 36, then if it were the case that section 36 was disapplied until an application for registration had been made, it would require the person claiming to be the licensee to be the person bringing the proceedings to which 36 refers. So in my submission, the interaction between these clauses is such that section 25(3)(b) simply does not, regardless of the state of registration of a license, disapply or prevent from applying section 30 subsection 6. And those are submissions that the judge accepted. In my submission he was right to. Now, there are other points that are taken by my learned friend in respect of section 30 that I should address. And this is where the structure of my submissions may become less coherent than is ideal, which I apologise. But my learned friend's points were that section 30 provides so this I think was his third submission in support of his proposal as to the way these two sections should be interpreted. Section 30 provides a coherent waterfall, was the proposal. And that was a submission that was made earlier and then developed in the course of submissions directly on this section. And as I understand the proposition, it's this, is that looking at the, if I may return your lordships to it on page 390 of the authorities bundle, the structure of section 30 that my learned friend took you through was that section 30 subsection 2 provides for the licensee to be entitled to ask the proprietor to bring proceedings. And I understand that as a consequence of that, it was submitted that section 30 subsection 6 is the consequence of section 30 subsection 2. So it is when a licensee has asked the proprietor under 32 to bring an action that 30 subsection 6 is commencing in infringement proceedings brought by the proprietor means such proceedings brought as a consequence of 30 subsection 2. So in response to that, I say, first, that improperly reads in words to 30 subsection 6 which are not there. They do not say where a proprietor has brought proceedings pursuant to subsection 2. Contrast that to
Well, you're right, it doesn't cross-refer, but what other circumstance could it apply? Because if the licensee brings its own proceedings,
Yes.
it doesn't need the proprietor to claim on its behalf.
So, my lord, it applies in circumstances where the licensee hasn't asked. So, the proprietor, perhaps proactively, or at least because it has its own interest in controlling infringements, brings the proceedings itself. That is I would say, I'm sure, more common occurrence than a licensee encouraging, asking, and causing the proprietor to bring proceedings. And that alone, in my submission, is an indicator that Section 30, subsection 6 must have its own independent role to play that doesn't depend upon Section 30, subsection 2, or indeed any other prior subsection of Section 30.
Well, in that case, if you say it's more likely, the effect of sub 6 is to make sure that the court can ensure that the proprietor has to account to the licensee for any award that includes licensee losses.
Has that option in its discretion to do so? Yes.
Yes, so it does have an impact whether or not there's been a request for the proprietor to enforce.
My lord, yes, but my submission is that is indicative of Section 36 not being something that is only engaged when some of the other mechanisms in Section 30 have been deployed. And that in my submission is, so as I understood my learned friend's submission on the point, he says, well, when Section 25(3)(b) refers to the rights and remedies of the licensee or the protections of Section 30, he says, well, that must encompass 32 because that is a right of a licensee. It begins a licensee is entitled, etc. He says that because 32 is a protection of the licensee, that 36, which follows from it, therefore Section 36 must be a protection of the licensee. So it's
how does this work? Let's take the proactive proprietor you postulate.
Yes.
So the proprietor brings claim without even asking the licensee, and before the licensee has had a chance to ask the proprietor.
Yes.
So subsequently, the licensee then has a choice. The licensee can ask, in which case the licensee will be joined as an additional claimant if the proprietor consents, or the proprietor doesn't consent, in which case there's no ability for the licensee to join.
Well, my lord, no, that's not the way that the section would operate. So, if the proprietor brings a claim, that's it for the licensee. The licensee cannot. So
I don't get it. Sorry, you're saying a claim by the proprietor
yes
precludes
yes
the licensee from invoking the right under subsection 2?
Not under 2, my lord. No, but it would. So I'd understood your proposition to be that once the proprietor had brought the claim, that then the licensee would say, well, please bring this on my behalf as well, and the licensee would then be joined as a party.
No, I'm supposing that the licensee then invokes its right under subsection 2.
Yes, and says, please take infringement proceedings. Well, they're already in existence. So in my submission, that's indicative that Section 30, subsection 6 can't be dependent on this mechanism.
Oh, I see. You read it together with subsection 3. Yeah, I get the point.
Well, yes. So it's only if the proprietor refused that then the licensee would have a right, and then subsection 4. I mean, there's perhaps a disparity. Subsection 4 would require the proprietor to be joined to the licensee's action, perhaps as a passive defendant, but not vice versa. So the licensee doesn't get joined to the proprietor's action, and only can rely upon the court's discretion.
All right, but this all presupposes a proprietor who jumps in with infringement proceedings before the licensee has even had a chance to ask.
It does say, but my lord, that is, if I may say so, relevant as a forensic analysis of the structure of the section, in answer to my learned friend's proposition that section 36 is the consequence of 30 subsection 2. There must be
well,
an
it might be
application.
said that actually it reinforces his submission, because if we take your scenario that you're postulating, a proprietor who's so jumping the gun that he's beaten any chance by the licensee to ask, then the licensee certainly needs the protection of section 30 subsection 6, particularly the second half, doesn't he?
Well, I would say yes, madam, yes. But it doesn't mean that section is dependent on 30 subsection 2, and it doesn't therefore in my submission undermine my proposition that the correct analysis of 30 subsection 6 is that it's not at least the first part of it, the judge's findings, but I would say the whole thing, not a protection for the licensee.
Okay, thank you.
That was the point about the coherent waterfall. There was a second proposition made that, in respect of section 31, that, and again, this was a part, I think this was another proposition in respect of the coherence of it, that there were no circumstances in which a licensee might be sort of left out, as it were. So I think the proposition was made is that, well, section 31, and I mean 31, not 30 subsection 1, provides for rights of qualifying exclusive licensees. I accept that, it does. Non-qualifying exclusive licensees, therefore, fall within section 30 only. Then it was suggested, I think, that if my learned friends, or if my proposition was correct, there was a lacuna where a qualifying exclusive licensee, such as the second claimant, in fact, wouldn't be subject to, wouldn't be entitled to use any of the mechanisms of section 30. That in my submission is wrong, because it disregards section 30 subsection 7, which mean, in essence, that if a claim is brought by the qualifying exclusive licensee, all of its sub-licensees are just licensees within subsection 30. And one gets that from the terms of 30 sub 7. The provisions of this section apply in relation to an exclusive licensee, or to the extent he has by virtue of section 31, the rights and remedies of an assignee, as if he were the proprietor of the registered trademark. So for everything that says proprietor in 30, you read proprietor or qualifying exclusive licensee who's brought their own claim. So that was, I think, another point made in that regard. It was suggested that there's a consistent legislative policy of encouraging registration. In my submission, that is, as I mentioned earlier, in respect of the white paper, only a gentle nudge, and the policy of encouraging registration is met by this is really for ground 2, but met by the license being registered at any stage. And then it was suggested that there's a promotion of fairness. Claim should be articulated. And in my submission in respect of this, I think this follows from some of the submissions that are made in my learned friend's skeleton argument, which suggests that either one, my client will have a windfall, or that there's, in essence, some commercial decision that can be made by a party who may infringe another's trademark to decide, well, from what I see at the moment, I'm going to be subject to lower damages than I would be if some licenses had been registered and then make a commercial decision to, in essence, act unlawfully.
I'm not quite understanding your point that the policy in favour of encouraging registration, you describe it as a gentle nudge.
Yes.
Even assuming that's correct. How does registration at any stage, meaning at any stage, however late,
Yes.
serve that policy at all?
Because it means that at that late stage, a licence is registered, so more is on the register.
Well, like saying,
otherwise would be.
I've been driving without a licence, but now I've got myself a licence. That was all right.
Well, very different circumstances, if I may
Well,
say.
of course,
I'm
I'm saying it for effect, but
Yes.
I mean, to what extent does the last-minute registration of a licence or application for
Yes.
registration of a licence done only at the last moment only so as to validate a claim for loss? How does that feed into any policy
Well,
that might be devised?
my lord, it means that, of course, the circumstances are different because the licence has always existed. It's a question of the registration. If the registration or the application for the registration happens at a late stage, still that licence ends up on the register. Of course, some users may choose to register at an earlier stage, but the requirement for register, and I should be clear, this is really, although my learned friend made the proposition in respect of ground 1, it's really more relevant to ground 2. The registration is still encouraged by a requirement, even at a very late stage, to register. And in my submission, that's sufficient to meet the underlying intention to the extent that it existed. So, my lords, I think I made. I'm just, apologies for the hesitation in what I'm saying. I'm just checking whether points that were in my learned friend's skeleton have been taken orally. I don't believe that they have. Yes, there's the attempt to rely on section 30, subsection 6A, which is another aspect of my learned friend's propositions. Now, in respect of this, you have, of course, my submission already that subsection 6A is not part of the relevant statutory scheme that is for you to consider, and so has no relevant impact on the position to be assessed. It was my learned friend's proposition that, maybe it wasn't a proposition, but stated that his and his team's researchers haven't been able to identify the rationale for section 6, capital A. The rationale for it is that it came in with the 2019, my learned friend mentioned the 2019 coming into force amendments of the intellectual property regulations of 2018. Their purpose was to transpose into national law the provisions of the recast trademarks directive. Now, unfortunately, there isn't a copy of that in the authorities bundle for me to show you, but that had an article on licensing expressly, and that provision 36A is practically verbatim a copy of Article 25. 4, I believe it is, at least Article 25 of the recast directive. And so those amendments to Section 30 are all, in my submission, intended to to comply with the UK's obligations that it then had to transpose that directive into its national laws. The recast directive had a policy of, as one of its intentions, a greater level of harmonisation amongst different member states, and adopted provisions that had been previously part of the community and then EU trademark regulation that applied to EU-wide trademarks, and that also had a voluntary system of registration within it. It may also be relevant to say that under that EU system, the lack of registration was irrelevant to whether a licensee was able to bring a claim as a consequence of a decision of the Court of Justice. But my short point in respect of Section 6A is it doesn't apply. To the extent that there is any point made on it, that should be put to one side because it's the wrong legislation. To the extent an explanation for the apparent overlap or difference between Section 6 and subsection 6A is sought, it is because 6A was there in order to incorporate the EU revisions into national law. And then I think the final point I need to address on the first ground, subject to lordships, of course, is the proposition about a windfall. And this, my response to that returns to my propositions at the outset when I was seeking to take you through the nature of the points of claim, is that what my clients have sought to recover for is the diminution in value of their registered right as a consequence of the acts of infringement that ended in 2016. It is not, in my submission, a windfall to my client to claim for losses that arise as a consequence of the the inability of my client's licensee then to sell goods bearing that trademark at a later date. It would be a windfall for the defendants not to be subject to an order that they pay damages that are caused by their acts of infringement. So I believe that covers all the ground that my learned friend addressed you on orally on ground 1. So unless I can assist you further, I'll turn to ground 2.
Thank you.
Ground 2, you've already seen several times today, section 25(3)(b. That provision you find at page 382 of the authorities bundle. Even my submissions already, I've focused attention on the first word of section 25(3), which is the word until. And in my submission, that is a crucial word in the determination of the effect of this section. It's obviously a term that refers to a set of circumstances that will stop when an application is made for the registration of prescribed particulars. Now, my learned friend wants to read into section 25(3) a requirement that it is prior to proceedings being commenced, or at least perhaps as an alternative, that amendments need to be made to proceedings in order to join in or claim for a licensee. But in my submission, none of that is a matter that arises from the section or from its proper interpretation. I say 2 points show that. The first is any time limit for undertaking the acts that the until refers to, i.e. the application for registration of the prescribed particulars is absent from section 25(3). And secondly, that absence of any expressed time limit is obviously in contrast to the content of section 25(4). So section 25(4) does have a time limit before the consequences of that arise, which is either A, within 6 months of the registrable transaction occurring, or B, essentially when that becomes practicable, if it wasn't beforehand, or C, before the acts of infringement take place. And so, in my submission, when the Act means to impose an obligation to register a license by a particular date and does so by reference to express language that requires that, it also sets out what the consequences of failure are.
Right, so you say it's a tougher sanction in relation to a lesser consequence. It's a tougher provision in relation to a lesser consequence, namely it's just about costs.
Which is, yes, so it's only, so it's now and at the relevant time only about costs. It was previously an even tougher provision, and that you see that on page 381. My learned friend took you
Except in this instance, it's the amended one we should be looking at.
absolutely, my lord. But the fact that it was amended in the way it was amended indicates that so there is an aspect of my learned friend submissions on this ground too, which seek to incorporate in section 25(3) a prohibition on the recovery of damages of a licensee that used to exist in 25(4) but was deleted by the legislature in 2006. And in my submission, that is a relevant factor to bear in mind when one's assessing ground 2 and to whether this the lack of registration, if it was required, can be cured. So in my submission, it can't possibly be correct to reintroduce or to say something that was always present, perhaps, via section 25(3), a proposition that was deleted.
Can you help me on that? I can understand the point that the meaning of section 25(3)(b), which has not been amended, can't be changed by an amendment to section 25(4).
Yes.
That point I understand. But insofar as your argument is based on a contrast between the two, why is the amended version not germane to that contrast?
So, my lord, apologies, I've amalgamated 2 points. So the contrast point must be a contrast with the content of section 25(4) as it existed at the time of the infringements, so the amended version. But there's a secondary point, separate, different point, which is in respect of the legislative history of the whole section, but that legislative history resulted in a change to section 25(4) only, because the intention, I think it's common ground, the intention of that legislative change to 25(4) was to do away with the pre-existing position whereby an entitlement to damages was lost by non-registration. And so my submission is, one, with that legislative background, one would be wrong to read section 25(3) as though it itself had a means of prohibiting damages recovery because of late registration.
You would accept, would you, that a licensee could not bring their own claim until they're registered, until the application for registration is made?
I do, my lord, yes.
Which means that if that occurs more than 6 years after the damage, the relevant cause of action arose, they'd be too late.
There may be a question about when the relevant cause of action arises in that case, because the relevant cause of action may arise when they register their licence.
Okay.
Because until that stage they had no ability to bring proceedings. There was nothing they could claim for. So, I mean, to that extent, yes. I mean, if I accept that the consequence of the Limitation Act is that if they do not file their claim until more than 6 years after their cause of action has accrued, it's statute barred. That's not a controversial proposition. But there may be a question as to when their cause of action does in fact accrue.
Well, you're linking it in this hypothetical example with the time when the licence is registered or applied to be registered.
My lord, yes.
Yes, so
yeah.
That would mean that somebody could extend the limitation period by waiting for as long as they could.
So, my lords, for those reasons, I say that the terms of Section 25.3 are very clear. They are only until an application for registration is made, unlimited in time. The judge was correct in his findings that they are not, that my clients were not limited in time as to when they made that application. There's one final point I wish to pick up. My Lord Justice Jackson, you had an interaction with my learned friend about the effect of the policy. So if the policy is that someone knows what is on the register, then that must mean, my learned friend put it, that the registration has to happen essentially preemptively in order that they can know who they might be liable to pay damages to. In my submission, and then the discussion reached at least the comment from your lordship that practically it may make no difference because the registration in fact might occur and the licence may appear on the register in a short period after the application was made. Now, in my submission, that may in fact be true, was true in the case of the harvest licence. But that practical difference in my submission is an improper factor to take into account in assessing what the statute means and what policy it's seeking to give rise to, what the policy it's seeking to give rise to is. So the fact that the only requirement is application for registration and that then the claim could be brought, issued, served on the defendant before they had any idea from looking at the register that an application had even been made, must indicate that the policy is not as stark as my learned friend suggests it is, and so it isn't one that requires appearance on the register. It is more consistent in my submission with my proposition that the only effect of the statute is to give, in essence, a gentle nudge towards registration. So one must apply, but no more. So it doesn't lead to a requirement that the defendant knows at the time of receipt of a claim form.
Well, I can understand your submission that the length of time that it actually takes in practice isn't a relevant consideration. Well, what do you say to the point that I made earlier, that the rationale is that the application date is under the control of the parties, whereas the registration date is under the control of the registrar?
Correct.
And that's why the statute says that the critical event is application.
Well, that, if I may, is consistent still with my proposition that the approach of the statute is not to require the licence to be visible before a claim can be brought. The fact that the activity is one that falls upon the applicant to register the licence, and that's in their control, doesn't indicate that the policy must be that the licences have to be on the register so that they can be communicated to potential infringers and the public in general. All it indicates is that there is, as I've described it, a gentle nudge towards registration which is satisfied by registration at any time.
The registrar is under a statutory duty to register. Now, obviously, how fast he moves is going to be a matter for him.
Yes.
But, I mean, in extremis, there could be an application for judicial review and an application for mandamus.
In order to force the registrar to,
yeah.
Perhaps so, my lord, yes. And the fact that is essentially accommodated and allowed by the approach that Section 25.3 takes indicates that it can't be seeking to put in or to give effect to a policy that requires the communication of the licence prior to issue.
Well, but that's the point I'm puzzling at. Because if the policy is to secure or to encourage, encourage registration of licenses. Surely the presumption of the legislature is that the registrar will do what he's supposed to do and do so in a reasonably timely fashion. It may be very quick, as happened in this case. It may be slightly less quick.
My lord.
But the presumption of the legislature is that the registrar will do what he or she is supposed to do within a reasonable time.
My lord, yes. But in light of that, if it had been the legislature's intent that the registration had completed by the time that the acts of the licensee could be commenced, then one might infer that they would have said so. It wouldn't have said until an application is made. So in my submission again, that is consistent with my submission on the very limited policy that this seeks to give life to. Bearing in mind, of course, I accept the proposition that the legislature would have been entitled to, and perhaps probably did, assume that the registrar would act quickly to register licenses, particularly given the less onerous conditions that in comparison to the previous approach. Then if communication by registration was a prerequisite, then the section would have been drafted differently in my submission. I finally said there were a number of points taken in my learned friend skeleton argument not covered orally. I'll leave them addressed in my skeleton argument to the extent they're still relevant points. So, my lords, I think I've exhausted my time in any event, but unless I can assist you further, those are my
Thank you very much indeed, Mr. Sutherland.
Lord, I hope briefly, first briefly, Shahabi, only because it's a fairly peripheral part of this case, albeit it's a slightly interesting point, the notes and clauses point. Shahabi, your Lordship may have put it into the end of the authorities bundle, starting at 534, in the analysis my learned friend showed you. As I understand it from this judgment, the position, the factual position was as follows. Prior to 1990, these things called notes on clauses were private. And there's no doubt that at that stage they're not admissible because they were privately administered. Post 1990, and therefore well into 1994, they were made available to members of Parliament. So they were available to members of Parliament, and therefore not in fact the situation in Shahabi, which is pre-1990. Now, the extract from Mr. Justice Sales's judgment at paragraph 59 on page 534 suggests that notes on clauses should not be admissible as aids to construction, pre-1990, because they weren't even shown to members of Parliament, but post-1990, because they weren't available to the public. So that's what Mr. Justice Sales says. If they weren't available to the public, they can't be a useful interpretation, it's a source of interpretation. What we have here, so it appears, is these notes, 1994, and therefore made available to members of the public. And we know that they were available in the House of Commons library. They weren't, it seems, online as in the Supreme Court case, so we're somewhere in the middle. There it is. Clearly, there's no absolute ban to notes on clauses as per the Supreme Court, paragraph 60.
Well, there wasn't an online.
There wasn't an online in 1994. So there we are. We're somewhere in the middle between all the cases. That's why I say I'll raise it. I don't think your Lordship need to resolve this critical point.
This is not going to be hunted down.
No, exactly.
In this case.
Well, that's that. Now, one point, just to follow up one issue raised by our friend on the pleadings, and when he told your Lordship that Harvest was the exclusive licensee in the UK, just a little bit of caution about that. And
do we have the license on?
There's a license in the confidential bundle, which I wasn't going to take your Lordship to at some stages in the confidential bundle. What I was going to show your Lordships was that we'll go back to the pleading or the amended points of claim, where we get some, and your Lordship saw some of it, but maybe not all of it, some indication, and there's so much obscurity about all of this is one of the inherent problems. But as your Lordships picked up, if we go to paragraph, it's core bundle tab 15, paragraph 45, 40, page 204, the first heads of claim are in relation to EU licenses at 39. And you also will have seen the structure of this claim, which is 40 is the licenser's losses and 41 is the corresponding claimant losses. And we don't have a complaint about the corresponding claimant losses. You're entitled to refer to a license in order to claim claimant losses. That's not a problem. But just to give an indication on the numbers, for example, paragraph 40, these licensees' losses are £74,000. The claimant losses in 41 are £16,000. So you can see the disparity again here. So the first set of, these are EU licenses referred to in 39. There's then 43, a UK licensee who is not, I think, Harvest, but is referred to as licensee A, who's said to have suffered loss in relation to underwear. And there's a calculation of loss on that. And just if it matters, on paragraph 48, the licensee loss for this one is said to be £995,000, and the claimant loss in paragraph 50 is £58,000. So enormous disparity for these. But what then happens when we get on to page 206? It's not a, what one might think is at least a conventional damages claim. It's a damages claim which is calculated, as you see at the top of the page, on projections. And there are three models that are put forward as projecting what losses might look like on these different analyses. And as I understand it, they're alternative, but they're setting out ways in which losses might be calculated by reference to different criteria. So the first one is at 52, is by reference to sales by a licensee number 5 in Italy, and that's then said to kind of project back into sales by anonymous licensees in the UK. There's then at 58 projection based on UK sales, as you'll see, and you'll see there A licensee is referred to at 58. This one doesn't even get the moniker of licensee B. This is just a licensee apparently commenced sales of menswear to the UK retailer TK Maxx. So that's another UK licensee unmentioned, but apparently has some relevance for the purpose of calculation of loss. And that's when in paragraph 64 of the page we then get to Harvest. So Harvest is not even a claim by Harvest in respect of Harvest losses. Harvest is part of the projection, or a different means of setting out the projection for some form of collection of licensees' losses that might be calculated. So Harvest isn't actually even a claim as such by a licensee, it's a projection, and that's why Harvest comes in. So there are three projections, an Italian licensee, an unnamed licensee, and Harvest. Each of them is said to give rise to a methodology by which this court will, at some future stage, apparently, calculate loss in respect of some currently unregistered and wholly unidentified licensees. That's this claim that we're dealing with. That doesn't go to the legal points, but it shows that factual position and exacerbates or highlights, we say, the position the defendant is in. So that's the second point. Now, again, I'm not sure this especially matters. One of my friend's submissions going on to this statute was he said that Harvest couldn't bring a claim. First of all, he said that Harvest couldn't bring a claim at all because the claim had already been brought by his clients. And therefore Harvest, whose license only appeared after the proceedings had been brought, couldn't have brought a claim. And the answer to that, as alleged, was it couldn't make a request for Harvest, for the claimants to bring a claim, because the claimants had already brought a claim. Well, it doesn't matter for present purposes, but we don't necessarily think that is right. Under section 30, one of the situations where you've now seen it so often you can probably recite it by memory, but under section 30, which is page 388 or 390, the request isn't any request by a proprietor, by a licensee. The request is for the proprietor to bring proceedings in respect of any matter which affects his interests. That's what the request is about. It's not a request to bring any sort of claim. It's a request to bring a claim in respect of a matter which reflects his interests. So if the proprietor, what is envisaged in this section, I submit, albeit again it probably doesn't matter, is that a proprietor won't go off and claim for licensees' losses off his own bat. Why on earth would he? The proprietor would claim for his own losses. If the licensee wants to bring his own losses into claim, he makes a request. That seems to be what's envisaged. But we don't accept that in that scenario that the licensee couldn't then engage 33 if in fact the proprietor didn't bring a claim in respect of a matter which affects his interests. So what it matters, Harvest couldn't bring a claim, but Murphy did accept eventually that the respondents could bring a claim. So Harvest does not lose out on any analysis of the section. Moving on, similar point still in section 30, Murphy said, paragraph 36, it must be an independent right, and that I'm wrong to say that 36 is linked to 32, because there could be a scenario in which a proprietor brings a claim without a request. Again, this section doesn't envisage that. This section envisages parties that look after their own interests. And if a proprietor brings a claim for his own interest, he can do so. If a licensee wants the proprietor to bring a claim for his interest, he's got to request it. That's what's envisaged by the section. And that's why we say it works as a coherent whole. But it doesn't really matter if it's possible to envisage a situation, unlikely though it may be, and not in fact this case either, by the way, where a proprietor runs off his own bat and brings a claim for licensee losses without a request, but you're still within section 36. You're still within a claim by the proprietor for the licensee. And there was, I submit, an important concession by my friend when asked about his mandatory point. Because the skeleton very much takes the line, it's mandatory. Either the court must take into account the losses. And that has the benefit of, at least simplicity, one can understand, well, looks at the words and that's what it says, so there you are, that's the argument. When asked on this, my friend accepted that it would only be engaged if the losses were in fact pleaded. You might say, well, obviously. But that's quite an important concession, we say. Because if a proprietor brings his own claim, as here, it's not a claim for licensee's losses at all. It's a Section 14 claim. If a proprietor brings and pleads a claim for licensee's losses, of course it's a protection for the licensee. That's not a proprietor's claim at all. It's a licensee's claim through the medium of the proprietor. As soon as he accepted that Section 36 is engaged when the proprietor pleads a claim for licensee's losses, one can immediately see it's obviously a protection of the licensee. It's not a protection of the proprietor at all. Next point Murphy made on the first ground about what he said, the windfall. He said it wasn't a windfall because the proprietor would be claiming for the diminution in the value of its registered right. Now, maybe, but I think there's a bit of playing of words here. Yes, the source of all the rights in an infringement claim are the proprietor's registered right. Of course they are. That's the source of everything. But insofar as that diminution is in any way reflective of a claimant's loss, of a proprietor's loss, then it's Section 14. So any relevant diminution that goes to the claimant, proprietor, is a Section 14 claim. What we are concerned with is a diminution that goes to the licensee's losses. So one can't elide the two and say, well, it's all about the diminution in the value of the rights, because we are talking about two very different parties seeking different remedies. And again, once one realizes the difference between Section 14 and Section 30, it becomes, we say, obvious that this is a protection for the licensee, not the proprietor. That's issue one. Issue two, briefly as I can, there was, with respect, no explanation from another friend when asked about the policy which his interpretation would achieve. Because there is no policy which could possibly be achieved by last minute, literally last minute registration. The best we got, with all respect to my friend, was that the application is the trigger, and therefore there may be a possibility of an application being made without it having reached the register and legal proceedings having been begun before it gets onto the register. So be it. Unlikely, though it may be, not envisaged all that much by the legislation, it may be a small lacuna and a small delay. That doesn't justify, with respect, an argument, therefore you can delay forever. The suitors simply don't follow at all. And last point, if I can read my notes, is Section 25.4. 25.4 is a different remedy. It's dealing with substantive rights to claim rather than the process by which Sections 30 and Section 31 are engaged. The reason it uses the word unless, if one goes back to section 25.4, we can see it in our other version, that go to the current in 383. The reason it uses the word unless is because of the 6-month window. So there's not a cut-off point in section 25.4. An application for registration can be made within that 6-month period, and you still have all the rights. That's why you need unless. It's not an until, it's an unless, because it must be made within that period. That's the reason for the difference between the wording. It doesn't tell you anything about what until means in 28.3b. In fact, for what it's worth, and I've said a lot of things, I think, in reply that don't really matter, the relevant conjunction, if you're comparing, is not unless, is before. The unless deals with 6-month window. It uses earlier in the second line, before the prescribed particulars of the transaction are registered. That's the equivalent of the until in 28.3b, i.e. you have to do it. It's not saying you can never do it. You can do it at a late stage, but it doesn't tell you anything about what you've lost in the meantime. That's the relevant conjunction, which is for these purposes equivalent, until and before, for what it's worth. But it's not unless, because that deals with a very different point, it's a 6-month window. So, Lord, those are my submissions in reply.
Thank you both very much, and thank you to all those who've supported you in preparing this. The Court's grateful to you for completing your argument within the course of the morning. It's the sort of argument that could easily have gone on for longer, and it wouldn't have been any better. I think we might consider rolling this out more generally. I say this because I have to, obviously once we've taken the necessary time to consider our decision, we'll let you have it in the form of draft judgments. Those draft judgments, I emphasise, are entirely confidential to the individuals who are named on the distribution list, and it would be a contempt of court for them to be treated in any other way. So please take great care with that. Let us have your assistance with any factual editorial corrections and a draft order reflecting our decision, if you'd be so kind. If there are any matters that you can't agree, then you make short written submissions about them. We won't need to trouble you at that stage, in all likelihood, to return to argue them, and the judgments will then be handed down on the National Archive in the normal way. We have held over the cross appeal on the terms of our previous order, and we'll pick up the threads of that when we see what your submissions about that matter are, if they can't be incorporated in our draft order. Richard, anything else? No. Thank you all very much.